Well, the review petition filed on 2nd of June, my lord. No prayer for listing the day after today.
What?
So may I please, Lordship,
Yes.
May I please, Your Lordship? Lordship, I beg to mention for listing of an IA, Your Lordship, on last two occasions, due to paucity of time, could not be listed.
Yes.
For delay.
22nd June.
Second,
June.
July.
June.
may I please, Lordship, I filed on CRP IO, Lordship. 2-3 occasions came due to some instruction. I could not continue, Lordship. Matter is urgent pertaining to my one order, Lordship. Can it become tomorrow, Lordship? Small issues, Lordship. Last 1st June it came due to instruction. I could not continue, Lordship.
Okay.
May I please, Your Lordship? I beg to mention for listing of a IA in a second appeal, Lordship, for orders.
22nd June.
May it please, Your Lordship. Malo RSA, my lord. I'm praying for listing in admission column. My
25th June.
obliged.
With the Lordship, I beg to mention item number 33 and 34 of the daily list, Lordship. I am appearing for the respondent number 1, 2, and 3. Lordship, I am filing a wakalat number today, Lordship. In instant matter, Lordship.
What is your prayer?
Prayer, Lordship, matter may be taken up after 2 weeks, Lordship.
Have
Or
you
after
informed the appellant?
Yes, I informed the Learned Counsel for the appellant yesterday, Lordship. 33 and 34, yes.
Heard, Mr. What is your name?
P. Das, Lordship.
P. Das, Learned Counsel for the respondent who submits that he has been engaged by the respondents in this case and you have already filed
But today we will file, Lordship. I
And
am for the
wo-
respondent 1, 2, and 3.
respondent number 1, 2, and 3 and would be filing his wakalatnama today only. And therefore he prays for an adjournment. He submits that he has informed Learned Counsel for the petitioner regarding his prayer for adjournment, who does not have any objection to the same. Hence the prayer is allowed. Let this matter be listed on 17th of July.
Lordship, extra copies of the bill may be provided to us because, Lordship, we haven't received any notice yet. As per my instruction, Lordship, since I have appeared before the lower court in the matter instant.
The appellant and the petitioner shall furnish copies of requisite numbers of copies of the revision petition along with the annexures to the Learned Counsel for the respondent number 1, 2, and 3 within 7 days from the date of this order. Yes.
May I please, Lordship? In item number 42, Lordship, orders item, Lordship. In this item, we have filed an additional affidavit, Lordship, on yesterday, Lordship. Kindly call for the same and take with the case record, Lordship.
Okay.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, item number 11, Lordship, bail hearing matter, Lordship. Your Lordship, this matter may kindly taken after 2 weeks, Lordship.
Why?
Why, Your Lordship, both the parties to want to settle the matter amicably, Lordship. So we need some time.
And Miss Emma Devi, Learned Counsel for the petitioner, who prays for an adjournment. The prayer is not opposed to by Learned Additional Public Prosecutor, and same is allowed. Let this matter be listed 27 July.
May I please, Lordship? I beg to mention for listing of an RSA, Lordship, for admission.
22nd.
I beg to mention item number 6, my lord. I am for the petitioner, my lord. I could not prepare the matter. Kindly fix it on either Wednesday or Friday, my lord. Motion, madam, my lord.
Motion. Heard Miss A. Gayan, Learned Counsel for the petitioner, who prays for an adjournment on the ground of personal difficulties. The prayer is allowed. Let this matter be 19th of June.
May I please, Lordship? Lordship, I beg to mention item number 9, Lordship. My friend is there, Lordship. It's a joint prayer, Lordship.
What is your prayer?
Can it be on 23rd of June, Your Lordship? In this matter, senior counsel Mr. Bidate will be appearing.
What is your name?
MM Zaman, Lordship.
Heard Mr. M. Zaman, Learned Counsel for the petitioner, who prays for an adjournment. The prayer is not opposed to by learned counsel for the respondent number 1, Mr. J. Das.
1 and 2 both.
1 and 2, Mr. J. Das. Hence, same is allowed. Let this matter be listed 23rd June.
May it please your lordships, with the consent of the other side, I'm mentioning item number 14. Lordship.
1-4.
1-4. Lordship, kindly list the matter after the vacation.
What is your name?
D and Das
Heard Miss D and Das, learned counsel for
appellant.
appellant, who prays for an adjournment. She submits that she has informed learned counsel for the other side regarding her prayer for adjournment. Hence, same is allowed. Let this matter be listed after vacation on a date to be fixed by registry.
Any date.
27 July.
Bless lordship.
Now, 4 and 5 may be taken together, my lord. Here, my lord, in this revision petition, I am challenging the order at page 31 in item number 4, my lord. The petition under
Is there any caveat?
from
Name of a council has been shown.
my lord, that is, I have noticed in the cause list, my lord. Four and
Item number 6.
6.
Mandel হইল।
6 number 4. Number 4. 4.
It took you
4 to be present.
4 and
My lord, he is present.
Yes, what is the
As page 31, my lord, in item number 4, my lord.
Please, your lordship. Sorry to interrupt, lordship. They may be directed to serve a copy to me, lordship. I have the instruction to appear in this matter.
Okay.
Is there any caveat?
No. Lordship, let this matter be taken on some other day, lordship.
What is the matter?
Matter, lordship, kindly come to page 31. I am challenging a order dated 5/3/2026, matter passed in miscellaneous J case number 199/2005 in title appeal number 3 of 2016, my lord, page 31 order. Here, my lord, a petition in the appellate stage, my lord. He has moved a petition under order 41 rule 27, my lord. Read with section 151 CPC to adduce, my lord, additional evidence. That was allowed. I am against that order, my lord.
When is the next date? When is the next date fixed?
Next date, 24/8, my lord.
24/8. Then let them file objection.
Lordship, by 24, by the, after reopening of
After
the
vacation,
vacation.
let them file objection.
Lordship.
I have an interim pair, my lord, that may be considered on the day, my lord. That may be recorded.
And Mr. J.C. Gogoi, learned counsel for the petitioners. What is the next case?
My lord, it is in the hearing stage, my lord.
No, the next item.
Next, the same, my lord. Arising out of another appeal, but order, different order, my separate order, separate,
But under order 21 rule 47.
same, my lord.
Order 21 rule. Under
Madam.
order 41 rule 27
Sir.
petition.
My lord.
Also had Mr. K. Jain, learned counsel for the petitioner. This application under section 115 of CPC has been filed by the petitioners, impugning the order dated 5/3/2026, passed by learned civil judge senior division Jorha in Miss J case number 119/2025, arising out of title appeal number 3/2016, whereby the whereby the appellate court has allowed an application under order 41 rule 27 filed by the respondent for reducing additional evidence at the appellate stage. Stop, learned counsel for the Mr. K. Jain, you have filed vakalatnama.
Lordship, I filed.
Learned counsel for the respondent submits that some time may be granted to the respondent to file written objection against the petition filed by the present petitioners. The prayer is allowed. Let this matter be listed on 28th July. Next matter, say,
Same, my lord, my interim page there, so it may be considered on the next day, my lord. It may be recorded, my lord.
we'll not record it. We'll see on that day.
My lord.
Well,
I have already served.
in the
copy.
next item, similar order, only case numbers will be
Case
different.
number will be different. It will be by the title appeal number 4 and Miss J case number 118.
Verify kar lena.
Order
Okay, same day.
same day.
Yes, Mr. Ali, you have anything?
This item number 6. I have responded caveat, your lordship.
Yes.
Without informing me, they have taken time. I have no objection to that. Only on Friday I can't, so I have some problem. So let it be on 22nd, Monday.
Okay. Item number 6. Item number 6 on 20th. Instead of 19th, it should be 22nd. Please inform the others. 22nd June. Okay.
Item 7.
May it please your lordship.
Yes.
Your lordship, here we are challenging the order dated 17/12/2025, wherein the petition of the opposite party for adducing certain PW documents as secondary evidence that was allowed.
Allowed.
So first, I'd like to take your lordship, the facts is that there was an agreement of sale between the parties. We are for the petitioner defendants.
Where is the impugn order?
Impugn order is at page 46. I'll read the entire order, very short order. The
Yeah.
plaintiff,
Yes.
46. Plaintiff and defendant, we are defendants here. Number 1 to 3 are represented. Learned counsel for plaintiff has filed evidence on affidavit of PW1, namely Bijoy Paul, along with a copy, and has exhibited some documents, furnished copy to the other side. Learned counsel for plaintiff has verbally prayed to file further evidence. The prayer is allowed. Learned counsel for the plaintiff has also filed a petition number so-and-so praying to exhibit documents 1, 2, 4, and 6 as secondary evidence, as the same has not been produced by the OC Moranhat even after notice. Since aforesaid documents are not produced after notice, to adduce secondary evidence is allowed. Now, your lordship will find this notice was issued before calling for these documents. The documents were in the possession of the Moranhat police station. Now, that order your lordship will find at page 43, 10/6/2025. I'll read the last para from perusal of record.
Yes.
Reveals that aforementioned document number 1 to 6 are essential for deciding the instance suit, and as such, petition filed by the plaintiff to issue notice for production of the aforesaid documents is allowed. Plaintiff is directed to issue notice to OC Moranhat for production of the aforesaid documents as per form number so-and-so, so-and-so. Now, thereafter, your lordship will find the next page. After receiving these notices from the court at page 45, I'll read that. There is a letter of the OC to the Honorable Court below. To the Honorable Court of Civil Judge Senior Division Charaida Sonari, submission of original documents, suit number so-and-so. Now, sir, with reference to the subject cited above, I have the honor to report that as per your kind orders, I am forwarding herewith the following original documents currently in the custody of Moranhat Police Station. These documents were submitted by Shri Bijoy Paul. He is the plaintiff at the time of reporting. That is affidavit bearing so-and-so and number 2 affidavit bearing so-and-so. it is further submitted that no other documents were submitted by Shri Bijoy Paul at the time of his submission to the police station. So only these two documents were the particular
Then
documents.
you can cross-examine when the documents will be produced, whether document have been exhibited, already been.
That can be cross-examined.
You can cross-examine, you can put this question.
But another aspect, Your Lordship, that this petition for calling for this secondary evidence, that was allowed on the same day itself without hearing us. At least one opportunity ought to have been granted. So this is only my case. Actually, they only submitted two documents at the time of lodging of the FIR. And the police has clearly revealed that.
Now, whether this document number 1, 2, 4, and 6
Yes.
have been exhibited.
That is part of the plaint, Your Lordship will find.
No.
The plaint.
As secondary evidence, whether they have been produced before the court.
Yes, obviously, because they have made it plaintiff exhibits as a part of the plaint. So those are there already as secondary, of course.
But whether.
Because they are alleging that the original documents is with the police.
No, they can exhibit it only after this order. Order dated 7/12/2025. At the time of exhibition, you will have the opportunity to cross-examine, and the plea which you are taking in this court, you can put that before the trial court.
That can be one opportunity to file an objection to this petition number 397 of 25.
What do you want now? Should we issue notice for this?
Should be issued.
No, whether these documents are exhibited or not.
As secondary, it is there, of course. Your Lordship will
No.
find. Yes.
Whether examination of plaintiff's witnesses has started.
Yes, that has started. As Your Lordship, it can be seen from this order. It was fixed for further PWs.
So, how many PWs have been examined? One.
Only one, I suppose.
Will issue notice. Heard Mr. S. Datta, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners, impugning the order dated 17/12/2025 passed by the Court of London Civil Justice Senior Division, Saraidev, in title suit number 5/2023, whereby the prayer for adducing certain documents as secondary evidence was allowed without affording any opportunity to the present petitioners to oppose the same. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the sole respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th July, list accordingly.
Obliged.
Well, this may be taken tomorrow, Lords.
Request of Mr. S.P. Roy, learned counsel for the petitioner, let this matter be listed on 16th of June 2020. Tomorrow.
Obliged.
Please, Your Lordship.
Here, my lord, I have challenged an order, my lord, which is at page number 139, my lord. Page number 139, my lord, and excerpt 15.
Yes.
My
Hey,
Yes, my lord. The fact of the case is that, my lord, there are two suits, my lord,
Mm.
regarding same plot of land. And the second suit, my lord, I filed a petition under section 10 of CPC seeking to stay that suit till the disposal of the earlier suit, my lord. That was rejected by this order, my lord. Sir. And here, my lord, the ground which was taken up for rejecting my suit is started from, my lord, 140, my lord.
yes.
From bottom, my lord, paragraph 2, my lord. I have gone through the photocopy of the plan of title suit 20621 annexed with the instant petition. On perusal of the petition, photocopy of the plan of the title suit number 206/2021, plan of the title suit number 10 of 2025, and a submission made, it appears that although the suit land involved in both the suit may be the same, the defendant in the present suit are, however, not identical to the defendant in the previously instituted suit, through some earlier, although some are similar. Further, the nature of the reliefs claimed in the two suits are completely different. It is requisite to mention here that mere similarity of subject matter or property is not sufficient to attract the provision of section 10 CPC unless the matter in issue in both the suit is directly and substantially the same, and the suits are between the same parties or parties litigating under the same title. In the instant case at the hand, since relief claim in both the suits are different and all the defendant of both the suits are also not identical, it cannot be said that the matter in the issue in the two suits is directly or substantially the same. Consequently, the essential ingredients in application of section 10 CPC are not satisfied. Therefore, I find that the present case does not fall within the ambit of section 10 CPC.
What relief is sought for in?
Here I sought relief the title suit number 10/2025, which is the subsequent title suit that may be kept in abeyance.
No. In
In both.
title suit number 206/21.
Yes, I have.
What is the relief prayed for?
Here, my lord, there is a dispute, my lord, regarding a plot of land. In the earlier title suit, that is 206/2021, here the plaintiff, who are respondent here in, my lord, claim right, seeking a decree, right title possession of a particular plot of land. On the same plot of land, one portion of the said plot of land was sold to me, my lord. And that right title possession, trial for executing the right title possession of the plaintiff of the title suit when pending, one plot of land was sold to me, my lord. And thereafter in the second should come up, and the second should also, the same claim was made, the same prayer was made along with some other prayer, my lord. But the core questions, whether the plaintiff of title suit number 206 have legally right title possession over the said plot of land, that is still pending, my lord. In the second case, without adjudicating that, my lord.
Who is the plaintiff in the second suit?
In the second suit, my lord.
Who are you?
I'm defendant, my lord, in the second suit. We have purchased a plot of land from the scheduled plot of land which was pending in title suit number 206, my lord.
At what stage 21 suit is pending?
21 suit is in evidence stage, my lord.
What is the next date?
I have to take it, my lord.
At what stage?
The suit which I pray for kept in abeyance, my lord, that is next, that is tomorrow, my lord. For evidence, my lord. Still evidence has not been started, my lord.
Will issue notice.
Interim protection.
We have to examine before.
No, till next date, my lord.
No.
Otherwise, my lord, evidence has been taken up, my lord. Then
Nothing will happen.
Because without adjudicating, because right title possession, my right title possession.
Tomorrow suit will not be disposed of.
But the evidence, if evidence has been taken, it will, my lord, it will hamper me, my lord. That's why, my lord. Because otherwise,
how it will hamper you?
Because it is started, my lord, evidence is started.
But
my
you are
lord.
defendant in this.
Yes, I am defendant.
Evidence will be of the
Because,
plaintiff side.
The core issue that, my lord, if section 10 is,
We have to examine whether section 10 is applicable.
Next that your lordship fix a short date, my lord, till next date, my lord,
No.
till next date, my lord.
Heard Mr. M.A.I. Hussain, learned counsel for the petitioners.
I have annexed both the petition, my lord, here.
This application under section 220, under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 16/3/2026 passed by the Court of Learned's Civil Judge Senior Division, Dhubri, in major case number 44/2025 in connection with title suit number 10/2025, whereby the prayer made by the present petitioner for stay of the said suit in view of the pendency of an earlier suit, that is title suit number
206/2021.
206/2021 has been rejected. Let the notice be issued to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th July. You are there?
I am also there, Lordship, 6 to 9.
Okay. Also, Mr. T.R. Gauhati, learned counsel for the respondent number 6 to 9. Next para. Since Mr. Gauhati has appeared for the respondent number 6 to 9, no formal notice need to be issued to the respondent number 6 to 9. However, the petitioner is directed to furnish requisite numbers of copies of the petition along with the annexures to learned government counsel representing respondent number 6 to 9. List as
Both the suit filed by the same plaintiff, my lord. And
the
there is an identical
prayer for
prayer, my lord.
interim protection shall be, prayer for interim relief shall be considered only after due service of notice on the remaining respondents.
Item 49. My lord, fix the date, my lord. 24th July.
Yes.
Please, Your Lordship, my lord. Here in this revision petition, my lord, the title appeal is pending. During the pendency of the title appeal is admitted. The learned executing court file order dated 4/5/2026, my lord, issued the writ for possession, my lord.
You go before the appellate court.
We have submitted the petition, my lord. That is, our petition is at page, my lord, 61, my lord.
You have to pray for relief
Yes, my lord.
under order.
Page 61, we have already submitted the petition, but Learned Court, appellate court fixed the date on 6/7/26, my lord. And the execution proceeding will be on will be executed on 22/6/2026, my lord. On 22nd.
Which order you are impugning?
My lord?
Which order you are impugning? Appellate's court order?
No, my lord, I am challenging the executing court order, my lord. Since, my lord, we have also approached before the executing court, we have submitted all the documents, my lord, but same has not been considered, my lord. Your lordship may page 60, your lordship, found it. Both sides are represented in the petition bearing, lordship, got it? Page 60. married,
This order you are impugning.
my lord.
This order has,
Because, my lord, we have submitted a petition on the early date, my lord, and the learned court passed the order on the basis of our petition, my lord. But same has not been considered, my lord, on the next date fixed, my lord.
now what is the error in this order?
My lord,
What is the error in this order?
error means, my lord, since, my lord, we have submitted the petition, my lord, same has not been considered.
What
And
petition?
our, before the executing court, my lord. And the executing court passed the order at page 53, your lordship found it.
Which order you are impugning? Order at page 60.
Page 60, my lord.
Where is the error in the page 60?
Another thing, my lord, I am praying for your lordship. Your lordship, my date is, appellate court date is fixed on 6/7/26, my lord. In the meantime, execution may be stayed on the 6/7. Let the learned appellate court may decide my petition, my lord, on merit. Lordship may dispose of, my lord. That, to that extent, my lord.
Where is your application before the
Appellate court.
appellate court?
Page 61, your lordship may found. Annexure 8. There is a type copy and certified copy is at page 64, my lord.
This petition is under order 41 rule 5.
That is only on that petition here, my lord. The petition appellant has stated the humble petition of the appellants, my lord. And prior, your lordship, page 62, your lordship found. It is therefore prayed that your honor would be gracious enough to consider facts and stated above, and for answer of justice pass necessary orders to stay the execution proceeding in title execution number 55 or 25 pending in the court of the civil judge junior division number 2/5 Kacha Silchar in lieu of instant appeal till disposal otherwise.
Where is the order on this petition?
Appellate order, my lord, your lordship mounted page 67. 67.
No, where is the mention about your petition?
That on the next page, page 68. Later on, my lord. Next page. Later on, learned counsel appellant filed the petition number 467/12. Copy of the same duly received by under objection by the defendant and fixed the before the objection hearing for 467/12. 467 is my petition, my lord. That is your lordship found at page 64, my lord.
Before the appellate court, you have challenged the decree.
Decree, my lord. That was admitted, my lord.
Heard,
Appeal is admitted.
Heard, Mr.
I allow, my lord.
I. Alam, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 4/5/2026 passed by the Court of Learned Civil Judge Junior Division number 5 Kachar Silchar in title execution case number 55/2025, whereby writ for delivery of possession has been issued by the executing court in respect of decretal land in connection with title suit number 189/2021. Stop. Mr. I. Alam, the learned counsel for the petitioner, has submitted that the petitioners have preferred an appeal impugning the decree passed in title suit, preferred an appeal before the court of learned, which is
Civil Judge Senior Division number 1.
before the court of learned, Civil Judge Senior Division number 1, Kachar Silchar, against the decree passed in title suit number 189/2021. Stop. He submits that said appeal has been registered as title appeal number 42/2025.
Page 47, Your Lordship,
Stop.
found order.
He also submits that in the aforesaid appeal, the present petitioners, on 5/5/2026 have filed an application under Order 41 Rule 5 of the Code of Civil Procedure, praying for stay of execution of the impugned decree during the pendency of the title appeal number 42/2025. He submits that the copy of the said application filed by the petitioners has also been received by the respondent side. However, the appellate court has fixed the next date in the title appeal on 6/7/2026. The same day, the said date is also fixed for objection hearing on the petition number 467/2012. That is the petition. Why it is 467/2012?
12.
Why?
My lord, that is for that for which I have already read, my lord, for stay of the execution.
No, why it is 467 of
My lord,
12?
that is marked by the court, my lord, page 64, Your Lordship.
It ought to have been
Petition number.
467 of 2026.
12, my lord, that
Why it is? I am not
I'm-
understanding.
normally they have numbered the petition numbers, my lord, 467.
What 12 indicates?
12.
Year.
I don't think so, my lord, it's a year.
Then calculate.
In fact, my lord, I is alien number possibly, my lord.
Maybe 467/2012 within bracket. This application filed by the present petitioner for stay of execution. Learned counsel for the petitioner submits that in the meanwhile, the executing court of Learned Civil Judge Junior Division number 5 has already issued a writ by on 4/5/2026 and fixed the next date
On 22/6 to
on 22/6/2026.
2026.
No, it is only for submission of estimates.
That may be, but,
22/6/2026. Learned counsel for the petitioner submits that though the present petitioners have preferred an appeal against the decree passed in title suit number 189/2021 and also file an application under Order 41 Rule 5 for stay of execution of the decree. However, considering the fact that the appellate court has fixed the hearing of the petition on
6/7/20.
6/7/2026, unless, unless the proceeding of title execution case, title execution number 55/2025 is stayed till that day, the appeal preferred by the present petitioner may become infructuous. Stop. I have considered the submissions made by learned counsel for the petitioner and have gone through the materials on record. It appears that the next date before the executing court is fixed on 22/6/2026. However, the date fixed for hearing on the application for stay of execution filed by the present petitioner is on 6/7/2026. If before deciding the application for stay filed by the present petitioners, the decree is executed, the application for stay filed by the present petitioners as well as the appeal preferred by the present petitioner impugning the decree passed in title suit number
189.
189/2021 may become infructuous. As such, the proceedings as such, this revision petition is disposed of without issuing notice to the respondents by directing the executing court not to execute the decree passed in title suit number 189/2021 till the appellate court decides the petition number
467
467
stroke 12.
/12 filed by the present petitioners. That is the petition for stay of execution of the aforesaid decree. Stop. With above observation, this revision petition is disposed.
Obliged.
Order, I-17.
Yes.
I'm appearing for respondent number 1, 2, and 3.
Who is for the none has appeared for the appellant on call. Mr. S. Diffusa, learned counsel for the
1, 2, and 3.
respondent number 1, 2, and 3 is present before the court. On perusal of the office note dated 5/6/2026, it appears that the appellant has filed an affidavit in compliance
My lord, I have filed an affidavit.
served or not.
My lord.
Whether notice has been
Yes,
served.
my lord, I have filed an affidavit, my lord, regarding Dusty service, my lord. Flag A, my lord.
Affidavit in compliance in showing the service of notice on respondent number 5 and 6. Who has received?
My lord, the respondent number 5 and 6 himself, themselves, my lord, received this.
I have annexed the document.
showing the signatures of respondent number 5 and 6 on the copy of the notices. As such, the notices issued to respondent number 5 and 6 are held to be duly served. Any other
My service is complete, madam. So Lordship may fix this matter.
service is complete?
2014 matter. my
Let
lord.
this matter be listed for hearing for on 4th of August.
Complete.
Show the name of Mr. R. Sharma as learned counsel for the appeal. Instead of none appears, Mr. Shah.
Complete.
May I please your lordship? Lordship, I pray for some more time to bring on record the correct address of respondent number 5 and 6. We do not have the address yet.
What is your name?
Mr. S. Shom on behalf of Mr. S. Dutta.
Heard Mr. S. Shom, learned counsel for the appellant. Also heard Mr. Who is appearing? Mr. T. R. Gogoi, appearing learned government counsel, appearing for respondent number 1 to 4. Learned counsel for the petitioner seeks, learned counsel for the appellant, seeks some more time for bringing on record the correct postal address of the aforementioned respondents. The prayer is allowed. Let this matter be listed after three weeks on a date to be fixed by registry.
Obliged.
May it please, my lord. My lord, I am seeking 1 week time.
Or
Actually, the sole defendant has also expired, that sole respondent. And out of the 3 appellants, 2 have expired. So one is there. So within the course of the day, I'm filing 1 petition to substitute the defendant's legal heirs. That I'm doing. And just 1 week I'm asking for, because 2 appellants are also there, a lot of legal heirs. Some are not interested also.
let Mr.
MK Chaudhary.
M.K. Chaudhary, learned counsel for the appellant, who submits that in this appeal sole respondent has died, as well as appellant number 1 and 2 have also expired. He seeks some more time for taking steps for substituting legal heirs of the deceased respondent, and as well as taking necessary instruction in respect of the deceased appellant. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Item 20.
Yes, Lordship, we have not provided the extra copy, Lordship.
My lord, we're supposed to file an paper publication for respondent number 8. My lord, on account of financial difficulties, the appellants could not take the steps. Kindly grant 2 weeks time for respondent number 8. Paper publication on last occasion, there is an order. And with respect to respondent number 6 and 15, their now names may be struck off because they have not contested the suit by filing the written statement. And I will serve copies to the proper.
We will not strike out the name, we will dispense with the notice.
My lord?
We will dispense with the notice to them.
My lord.
And regarding furnishing memo of appeal to the government,
I will furnish. They are performer defendants. I will furnish.
heard Mr. A. Thor, learned counsel for the appellants. Also heard Ms. D.D. Burman, learned additional senior government counsel, appearing for respondent number
16, 17 and 18.
16, 17, and 18, as well as Mr. H. Das, appearing for respondent number 7. As well as Mr. M. B. K. Sinha, appearing for respondent number 3, 4, 5, 9, 10, 11, and 14. Stop. Learned counsel for the appellant submits that due to financial constraint, the appellant could not take steps for issuance of notice upon respondent number 8 through paper publication and seeks some more time for doing so. The prayer is allowed. The learned counsel for the appellant has also submitted that the respondent number 6 and 15 did not contest the suit before the trial court, and as such, their name may be strike out from the memo of appeal. Considering the submissions made by learned counsel for the appellant, the notice to respondent number 6 and 15 is waived, and the time sought for taking steps for paper publication is also granted. However, the appellant is directed to furnish requisite numbers of copies of memo of appeal along with annexure to the learned additional senior government counsel representing the state respondent within 7 days from the date of this order. List this matter again. What is your name? S.I. Mr. S.I. Talukdar appearing for respondent number 1 and 2. The date of the appeal, how much time you will take?
Well, after 8th of August, within 8th of August, we'll file.
No, what will be the date shown in the notice?
8th of August?
The date of appearance to be shown in the notice issued to respondent number 8 shall be 8th of, or you want it little more time?
8th of August.
8th of August. The appellant shall take steps tenth of August.
10th of April.
10th of August. The appellant shall take steps accordingly.
Obliged, Your Lordship.
Item 21.
Office note 11/6/26 suggests that no steps have been taken in respect to respondent number 5, 6, 7, 8, and 9.
None has appeared for the appellant on call.
Before earlier occasion also, they are not in absent on the last occasion also, Lordship.
Mr. S. A. Bhakhtiar, the learned counsel for respondent number 1 to 4 is present. It also appears that no steps for issuance of notice upon respondent number 5, 6, 7, 8, and 9 has been taken by the appellant in spite of the directions by this court. What should we do?
Also, let it be dismissed because earlier occasion also they were absent on.
We are giving one more chance.
Also, in the last order, they have placed a submission that their records have been misplaced. And for that, they had put sufficient time to reconstruct the record. But still, till now, they have not reconstructed and they have not repaired it also. So let it be dismissed for that. So that
Stop. One chance is granted to the appellant side to comply with this court's order. Let this matter be listed. 17th of July.
Item 22.
Yes.
May I please your lordship? Actually, in this matter, parties are ready to settle the issue with the defendants. So they are saying that matter may be sent for mediation. You know, this entire,
Who is for the defendant?
I'm for the appellant. We were the plaintiff in the suit. Second appeal is against the judgment of reversal. Trial court decreed the suit and dismissed the counterclaim. Entire dispute is regarding ingress and egress through a passage of road.
Yes, but
Basically-
today the council is not present.
Council is not present.
We'll fix it next week and in
It
present.
may be fixed next week.
Heard Mr. D. Majumdar, learned counsel for the appellant. None has appeared for the respondent. Mr. Majumdar submits that there is a possibility of amicable settlement. Hence, he prays for referring this matter to mediation. However, since no one is present today for representing the respondent, let this matter be listed next week, 22nd June.
Much obliged.
They have to take steps for report. 5. None present there, most probably 5, they have not contested the appeal either before the first appellate court. I am the plaintiff before the trial court.
None has appeared for the appellant. Mr. S.K. Poddar appears for respondent number
1.
Respondent number 1. On perusal of office note dated 21/4/2026, it appears that no steps for issuance of notice upon respondent number 5 has been taken by the appellant as was directed by this court. Stop. What to do?
They have not otherwise contested the suit. Yes, this chance may be given to them, Lord, by push.
One more chance is granted to the appellant side to comply with this court's order. Let this matter be listed. 20 July.
Okay.
Item 24.
My pleasure, Lordship. Lord, in this case on 24/10/2025, substantial question of law was formulated, but decree of the appellate trial court was not stayed. Instead of that, notice was issued.
Whether any execution case has been
Yes,
filed?
that is execution proceeding. That is the problem with us.
Have you filed any interlocutory application?
Yes. That this matter has been listed today. 39. Sorry, 3960 नंबर तो लगा
3960
अरे ये में तो है
ये तो वहां पे आपको
हमारा पास सॉरी 3916
Heard Mr. A. Das Gupta, learned senior counsel, assisted by Mr. G. K. Sharma, learned counsel for the appellant, who submits that in the instant case, the substantial question of law has already been formulated by this court by its order dated 24/10/2025. However, the execution of the impugned judgment and decree has not been put to any halt, and the respondent side have already, you were the defendant.
Yeah, defendant.
They have filed, what is the number?
The execution proceeding has been initiated.
What is the number of the execution case?
That number I can say. I simply here we shall pray for stay of this decree. That.
No, decree cannot be stayed. Execution has to be stayed.
Sorry, execution of the decree.
So, is there any execution case filed or not?
Yes, even with the file.
Where is
That is not with me, but I have the execution cases.
You find out execution case number. Will
That is
stay.
the trial court. Sir.
Execution is against you only. If there is an execution case pending, you must be knowing.
Yes, I know about that. Right now, I cannot say the number. Generally, without execution of the statement. That is the usual procedure.
No, I am also, suppose there is no execution case filed. Then what should be?
The Lord should make a record my technique. Yeah.
Learned senior counsel submits that the plaintiffs / respondents have already initiated an execution case before the executing court and hence prays for staying the execution of the impugned decree during the pendency of the instant appeal. Stop. Considering the submissions made by the learned senior counsel for the appellant and considering the fact that this appeal has already been admitted and the substantial question of law has also been formulated in this appeal, the execution of the impugned judgment and decree shall remain stayed during the pendency of the instant regular second appeal. It also appears from order dated 9/1/2026 that the notice issued to sole respondents has been duly served. Records trial court. Let the records of the trial court as well as first appellate court be called for. Registry to take steps for requisitioning the records. List this matter again on 24th July after receipt of the aforesaid records. IA and RSA common order.
Apologies, my lord. Item 23, my lord. My lord, at least my appearance may be recorded, my lord. I'll take fresh steps.
What is your name?
My lord, A. Bhatra, my lord, appearing for the appellants.
Later on, Mr. A. Bhatra, item number 23. Later on, Mr. A. Bhatra appears for the appellants and seeks some time for taking steps for issuance of notice on respondent number 5 as was directed by this court. The prayer is allowed. The appellant shall take steps within 7 days from the date of this order. Returnable on next date kiman asile 20 July.
Item 25.
May I please, my lord, office note dated 11/5/2026, my lord. Service upon 2A, 2B, 2C, 2D, and 3A, 3B, and 3C1, my lord, is waited, my lord.
When have you taken steps?
So,
Five 2025.
Lord, may I pray, my lord, if Lord allow me to take, my lord.
You have to take fresh steps.
My lord, as well as my lord, by way of Dasti, my lord.
Okay. Heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mrs. Paul, appearing for
Appearing for Mr. B.J. Mukham.
respondent number?
4 and
Appearing for respondent number 4 and 5. On perusal of the office note dated 11/5/2026, it appears that notice issued to respondent number 1 within brackets small a has been duly served. Stop. As regards notice to other respondents, namely 1A, 2A, 2B, 2C, 2D, 2E, and 3C within bracket C within bracket Roman 1 have not yet written. The appellant is directed to take fresh steps upon the aforesaid respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 27 July. The appellant is also allowed to take steps additionally by way of dusty mode on the aforesaid respondents. Stop. If in the event the appellant is able to serve the notice by way of dusty mode on the aforesaid respondents, the appellant shall file an affidavit in compliance thereto on the next date fixed. Let this matter be listed on 27 July.
Item 26.
May I please, your lordship?
Yes.
Lordship, kindly pass over the matter for the time being, as my senior is in legs on another court, before another court.
What is the matter?
Lordship, this is a transfer petition. Pleadings are completed, lordship.
Heard, Mr. What is your name?
Lordship, as thus.
As thus, learned counsel for the petitioner. None has appeared for the respondent. However, from the office note, it appears that an affidavit in opposition has been filed on behalf of the respondent, and same is available in the record. Hence, let this matter be listed for admission hearing on 17 July.
Deeply obliged.
Item 27.
May it please, Lord. So this is a transfer petition, Lord, praying for a transfer of a divorce proceeding, Lord, instituted before the Principal Judge Family Court to Sipsagar, Lord. Lord, the petitioner is the wife, Lord, and
Principal Judge,
Family Court, Kamrup Metro, Lord,
Kamrup Metro.
to Sipsagar, Lord. There's no dispute with regard to the marriage was solemnized in Sipsagar, and the petitioner, who is the wife, my lord, respondent, was staying in Sipsagar at the time when the petition was filed. That's not disputed by the respondent in their affidavit.
Then why it has been filed
But it's filed by the
in Gauhati?
taking the recourse of that they last resided together in Gauhati, my lord.
Okay.
And the petitioner, my lord, she has a minor son, my lord, and she's staying with her aged mother, my lord. So, in any case, my lord, she will have to leave both of them who are dependent to contest the proceeding.
The pleadings are completed, madam. Lordship may fix it for admission, madam, and dispose it of next day.
Oh, it is in orders. There is no hope of conciliation.
Perhaps not, my lord.
Not.
Perhaps not, because
Heard Mr. B. Kaushik, learned counsel for the petitioner. Also heard Mr. S. Das, learned counsel for the respondents. Since the pleadings in this case are complete, let this matter be listed for admission hearing on 24th July.
Item 28.
interim order may be continued.
The interim order shall continue with the next date.
But can it be 22nd, my lord?
22nd.
Or any
22nd
day after 24?
22nd July.
20. Really organized.
May I preside? Here I am appearing on behalf of the respondent lordship. They have filed a case for transfer from
as per annulment title suit 165/25 from Gauhati to family law. We don't have any objection.
You don't have.
Let it be tested. Because other cases are pending out here.
Heard Mr. T.H. Hajurika.
M. Setia on behalf.
Sorry. M. Setia.
On behalf of T.H.
On behalf, appearing on behalf of Mr. T.H. Hajurika, learned counsel for the petitioner. Also heard Mr. D. Talukdar, appearing on behalf of the sole respondent. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Urvashi Borwa, praying for transfer of title suit within bracket M number 165/2025 pending before the Court of Additional District Judge Jorhat, Assam, to the Court of Learned Principal Judge Family Court number 1 Kamrup Metro and Gauhati. Stop. Learned counsel for the sole respondent submits that since there are other litigation pending between both the parties in the Kamrup Metro District, hence the respondent does not have any objection if the prayer of the present petitioner for transferring the aforesaid case is allowed. In view of the concession, in view of the submissions of learned counsel for the respondent, the prayer is allowed. Let the records of case number title suit within bracket M 165/2025 pending before the Court of Learned Additional District Judge Jorhat be transferred to the Principal Judge Family Court number 1 Kamrup Metro. You will appear before the court. We will give a fixed date. Since both the parties are represented by their engaged counsel before this court, hence both the parties are directed to appear before the Court of Learned Principal Judge Family Court Kamrup Metro in connection with the title suit M 165 number 2025 within bracket to be renumbered may be renumbered in the family court on the next date fixed, that is August or a date. You choose a date.
First week of August.
5th of August. The Court of Learned Additional District Judge Jorhat shall ensure that records of the aforesaid case reaches the Court of Learned Principal Judge Family Court number 1 before the aforesaid date. This transfer petition is accordingly disposed of.
Much.
29.
May I please, your lordship? Lordship, as per the last order, lordship, we have take the steps for respondent number 11, lordship.
When?
Lordship, and this. Alone, it here 5/86. Lordship, on 8/6/26, lordship, we have take the steps.
Heard Miss S. Heard Miss
Sharma.
A. Sharma, Learned Counsel for the
Lordship, the 56 is also similar.
This item number is 29. Heard Miss A. Sharma, Learned Counsel for the petitioner. Also heard Miss F. Ahmed, Learned Counsel for the respondent number 1 to 10. Though there is no reflection in the office note regarding compliance of the order dated 8/2/2026 by the petitioner. However, learned counsel for the petitioner submits that the petitioner has taken steps for issuance of notice on respondent number 111 on 8th of June 2026. Stop. Registry to verify the same and list this matter again for the service.
Lordship, the 56I is there, Lordship, in 56, item number 56. 56.
Let me first dictate the order. 56 is related to this.
Yes, same Lordship, same
So-
Lordship, the I.
ले क्या लिखा again on 24th June. What for this I is?
Lordship, the substitution. Lordship, one is for substitution.
Substitution of
The respondent number 11, Lordship.
56 of Kita is.
Tintas.
Condemnation delay application. Which one is the condemnation delay application? Substitution of whose legal error? Three hundred and 52 days. You take steps in the condonation application. Notice to the heirs of the deceased respondent. What is the name of the deceased respondent number 11?
Himani Goswami.
And who are her legal heirs?
As it can be seen from the petition, Lordship, there is only one legal heir, that is Mamuni Goswami, who is the daughter, Lordship.
Who is Himani Goswami? Respondent number 11.
11.
Then you issue notice to Mamuni Goswami. In I number 1897, this interlocutory application has been filed by the petitioner in connection with CRP number 108/2025, praying for condonation of delay of 352 days in preferring the application for setting aside abatement as well as substitution of legal heirs of deceased respondent number 11. You have any objection? Though Miss F. Ahmed, learned counsel for respondent number 1 to 10, does not have any objection. However, let the notice be issued to the legal heir of respondent number 11. The applicant shall take steps for issuance of notice upon the legal heir of respondent number 11 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th July. Let this I be listed along with CRP number 108/2025 on the next date fixed. CRP किमान date दिसिलो? Same date कर दियो. 24/6. 24/7.
Immediate works. Steps log again.
May I please your lordship? Lordship, as per office note dated 9/6/2026, the records of the title appeal has been received, but the records of the title suit has not been received yet.
And Miss A. Sharma, J. Sharma, learned counsel for the appellant, also heard Mr. W. Hawk on behalf of Mr. W. Hawk, appearing on behalf of Mr. A. Sattar, learned counsel for the respondent. It appears on perusal of office note dated 9/6/2026 that the records of title appeal number 25/2013 have been received. However, the records of title suit number 17/2024 has not yet been received from the trial court. The registry to issue a reminder for the same. Let this matter be listed again after receipt of the trial court records on 24th July.
Oblige, lordship.
Cover করে নিন।
May it please your lordship. Lordship, in this matter, by office note dated 7/5/2026, lordship, process server report on respondent number 2 has been received, but no one has appeared till now. And respondent number 1, lordship, report has not been received, lordship. But lordship, respondent number 1 has not appeared in the MSc proceedings also till date.
What you are impugning in this?
Lordship, orders, lordship, dated, lordship, 18/7/2025 and 10/10/2025, whereby lordship, the evidence of the applicant was closed, lordship, in MSc case. Lordship,
Okay.
on 18/7, lordship, the matter was fixed for evidence, but lordship, the claimant, lordship, wanted to file his evidence, but because he did not appear till 3:30, it was closed. Thereafter, on the next date, on 10/10/2025, he filed a petition requesting for filing of evidence, but lordship, that was also rejected, lordship.
Now, what is the status?
Lordship, these orders have been stayed, lordship. The proceedings are stayed, lordship, now.
Now, what is your prayer?
Lordship, prayer is that these two, lordship, orders dated 18/7/2025.
No, regarding service.
Lordship, for service, lordship, respondent number 2, although they have received, but they have not appeared till date, lordship. And respondent number 1, since they have not appeared in the MSc proceedings also, lordship, most likely they are not going to appear, lordship, CRP. Till date, they have not appeared, lordship.
The MSc proceeding ex parte against.
Lordship, not ex parte, lordship, now it's fixed for lordship defense witness, DW, lordship. But now matters have been stayed after filing of this CRP, lordship.
Miss P. Burma, learned counsel for the petitioner. No, as regards respondent number 1, what is your prayer?
I can take fresh steps, lordship.
Okay. The On perusal of office note dated 7/5/2026, it appears that the notice issued to respondent number 2 has been duly served. However, none has appeared for the said respondent, whereas service report in respect of respondent number 1 has also not been received. The petitioner is directed to take fresh steps for issuance of notice upon respondent number 1 by speed post within 7 days from the date of this order, returnable on 27 July. The registry shall also issue reminder for scanned copy of the trial court records. Let this matter be listed accordingly.
Item 32.
After this. Yes.
As per office note, Lordship, 8/6/2026, Lordship. Service is complete, Lordship. PCR has been received. Matter will come for hearing, Lordship.
What is your name?
Be there, Lordship. Substantial question has been taken in this case here, Lordship.
Heard Mr. B. Deori, London, counsel for the appellant. Also heard Mr.
H.C. Sharma.
H.C. Sharma, appearing for sole respondent.
Yes, sir.
Appearing for sole respondent. It is submitted at bar that, it appears from records that this appeal is ready for hearing. Hence, place the same for hearing on 20 August. I'm taking a short break.
Item 45.
May it please your lordship. Lordship, as per the office note 11/6/2026, unserved notice has been returned upon the respondent number 2 and 4 due to insufficiency of address. Lordship, 2 weeks time may be granted for taking instructions for the proper address.
Heard, Miss, what is the name?
D.N. Das.
D.N. Das, learned counsel for the petitioner, who submits that in view of the office note dated 11/6/2026, the petitioner may be granted 2 weeks' time to find out the appropriate address of respondent number 2 and 4. The prayer is allowed. The registry is directed to place the postal tract consignment report in respect of notice issued to respondent number 1 and 3 before this court on the next date fixed. Let this matter be listed early. 29 July.
Item 46.
May I clear up? My lord, in this case, notice were allowed to be issued. And on last date, my lord, on 18th, last order may kindly peruse. That order is 18/3. 18/3, and the last line, my lord, the prayer for interim shall be considered on the next date. Here, my lord, the matter was that.
Next date has lapsed. Next date was 8/5.
8/5, yes. But 8/5, they have taken adjournment.
So what is your prayer?
Yes. Now it is that, my lord, my prayer was that the order, my lord, at page 13.
Whether all the respondents have appeared?
Yes. Respondent number 2 is appearing.
Respondent number 1?
1, we have taken the steps. But, my lord, the lower court is proceeding with the matter, my lord. Here the matter was that the lower court passed the order for sending of some document for forensic report. And in that, my lord,
a peculiar direction was passed, that is, whether the signature appearing on exhibit 1, 4, and 5 at page 48, I am reading, my lord. Page 48. Last line. Whether the signature appearing on exhibit 1, 4, and 5 are forged or merely imitated version of the signature appearing on the will dated 10/6. My lord, regarding forged signature, that cannot be examined without sending the admitted document, my lord. So it is a will, my lord. So there is no admitted signature. And if it is sent, my lord, what report will come from the FSL, my lord?
Yes. On that ground only you are.
Yes, yes. So trial court is.
When is the next date?
There is the 20th, my lord.
Bill has already been sent.
No, it has not been sent. We have requested that matter is pending in the High Court. So 20th date is given, my lord.
You are the plaintiff.
Yes, and the plaintiff there.
Let it be examined by the forensic.
But
let them say that we need a
regarding
admitted document.
Which I mean, it was a will, my lord. So
no, forensic laboratory will need something to compare some admitted signatures with which.
Admitted signature is not there, my lord.
So let forensic laboratory say that unless you send a admitted signature to us.
Unnecessary, the matter will be delayed, my lord. It may be disposed of on the next date, my lord, if they appear, the respondent appear on the next date, my lord.
Okay. The order may need some modification.
Yes. I only prayed that the order may be kept in abeyance, the direction of the trial court. At page 13, the entire proceeding did not be stayed, my lord.
Okay.
Only that direction.
Heard Mr. J. Sharma, learned counsel for the petitioner. Also heard Mr. S. Bhattacharjee, appearing for respondent number 2. On perusal of office note dated 6/6/2026, it appears that the service report in respect of notice issued to respondent number 1 has not yet been received. What will you do? You will take fresh steps.
We will take the fresh step. On the new address, my lord.
You have the new address.
We will collect the new address because on earlier the address, my lord, notice could not be served like that.
No, notice has not yet been received.
Or that is pending, my lord.
The petitioner is directed to take fresh steps for issuance of notice upon respondent number 1 by speed post. Speed post within 7 days from the date of this order, returnable on 29 July. Learned counsel for the petitioner further submits that in this CRPIO, the petitioner has put to challenge order dated 10/2/2026 passed by the Court of Learned Additional District Judge number 2, Kamrup Metro in title suit probate title suit number 4/2020, whereby the
Page 48.
forensic laboratory Kahlipara has been requested to conduct examination of exhibit 1, 4 and exhibit 5. What are these exhibit?
Exhibit 1 is the will, my lord,
4,
and 4 is the authority letter, and 5 is the will which has already been revoked.
4, 1 and 5, along with the will dated 10/6/2017. To furnish a report as to whether the signatures appearing in exhibit 1, 4 and 5 belong to one and the same person or not. This can be ascertained.
My lord, this can be valid.
Secondly, whether the signature appearing in exhibit 1, 4 and 5 are forged signatures. Forged signatures. But it has to be compared with will dated 10/6.
10/6, already the report of SFL is there, my lord.
What?
That report is there, my lord, at page. We have submitted the report, page 34.
What is the report?
That report is that the signature appearing thereon are not the one and same person. Two different persons have put the signature. So they want that it should be compared with that will, my lord.
In exhibit number 1, 4 and 5 are forged signature and are imitated version of signatures appearing on will dated 10/6/2017. Learned counsel for the petitioner submits that the signatures appearing in will dated 10/6/2017 were earlier sent for forensic examination, and a report to that aspect. Where is the report?
That report is page 34.
Report in that regard has been furnished by the Joint Director, Directorate of Forensic Science, Kailipara, on 6/12/2025, indicating that the signatures appearing on will dated 10/6/2017 are written by two different persons. As such, he submits that unless a document containing admitted signature of whose signatures are in question?
Whose signature, my lord? The
Who
Anandamai Bezbarwa.
admitted signatures of Srimati Anandamai Bejbarua are sent to the forensic laboratory. It may be difficult on the part of the forensic laboratory to compare the signatures of appearing in exhibit 1, 4 and 5 with signatures appearing in will dated 10/6/2017, which is already held to be carrying signatures of two different persons by the forensic laboratory. Hence, he submits that the impugned order may require to be modified after hearing both the sides. He therefore submits that unless the operation of impugn order is stayed, it would be only a wastage of time if the said exhibits are sent to the forensic laboratory without modification of the said order. Stop. I have perused the opinion dated 29/11/2025 of the forensic laboratory in respect of the how we will know that it is in respect of 10/6/2017 will dated page 34. Come to page 34.
Yes. Yes. That will date is not given, but the will is this, that will was sent for FSL, my lord. And that report is there for that report, my lord. Because two different proceedings are going on. One in respect of the will.
In respect of will dated 10/6/2017, which indicates that the signatures appearing thereon are by two different set of persons. Hence, the contention raised by the learned counsel for the petitioner is required to be examined, and the operation of impugn order dated 10/2/2026 passed in probate title suit number 4/2020 may require to be kept in abeyance, is required to be kept in abeyance till this CRPIO is heard and disposed of. Accordingly, the operation of impugn order is stayed till next returnable date. The proceedings of probate title suit number
4/20.
4/20. 4/20.
Before additional district judge.
4/2020 shall continue and no stay is granted on the said proceeding. Let this matter be listed. 29 July. Only order is stayed.
Yes, order, my lord, two orders are there, 10/2 and 24/2.
What is 24/2?
24, the review on my review petition, this was dismissed, my lord.
That means original order remains.
Yes, that will do.
Original order stays
Yes,
also.
yes, that will serve the purpose.
Let this matter be listed again on 29 July.
Good day.
Item 47.
But please, your lordship.
Yes.
Lordship, step has taken on 12/5/2026.
12/5.
2026.
Heard. What is your name?
H. Ahmed.
Heard Mr. H. A. Ahmed.
Interim order dated 11/5 shall be continued.
The learned counsel for the petitioner. On perusal of the office note dated 11/6/2026, it appears that the service report in respect of sole respondent is still awaited. The registry is directed to place the postal track consignment report of notices issued to sole respondent by speed post before this court on the next date fix. Let this matter be listed 15th of June. Today is 15th June. 15th of July. The interim order granted earlier shall continue till next day.
Oblige you.
Item 48. May it please the Lord, sir.
May it please the Lord, you also pray for 1 week time to file a reply. Your Lordship.
Appearance is complete.
Yes.
This is condonation.
Yes.
Condonation, my lord, substitution and setting aside of abatement, my lord, of the sole respondent.
Okay. IA 326. 326 is for condonation.
Yes.
Yes.
Heard Mr. S. Das, learned counsel for the applicant. Also heard Mr. S. Diffusa, learned counsel for the respondent, who prays for some time to Allah for filing written objection against the prayer for condonation of delay made by the applicant. The prayer is allowed. Let this matter be listed again on
17 June.
17 July.
Oblige you.
File your.
Item 49.
May I please the Lordship. This case service is otherwise complete. The counsel for the other side has entered appearance. On the last occasion also, this matter has come up for admission. This matter may be taken up on the next date for admission, Lordship. Sir, on a very narrow campus, this matter.
What for IA is there?
This IA, they filed an application before this honorable court stating that the amount of maintenance was not paid before the concerned family court. So it has already been paid on 3rd of June. The 30,000 amount has been paid.
You have
Probably
received?
She has received the amount.
Yes.
So this matter is otherwise ready with regard to service.
Okay.
So next week, if the Lordship pleases.
What are you impugning?
My lord.
What are you impugning in this order?
No, Lordship, here in this case, file an application before the learned family court. Lordship, the application is at page number 15.
CRPI.
Yes, with a prayer, very limited prayer, Lordship, we want to adduce further evidence. And that application has been rejected by the learned family court.
Okay.
Page number 15, annexure 2. This is the application that was filed before the learned family court.
Heard Mr. S.P. Chaudhary, the learned counsel for the petitioner. Also heard Mr. What is your name?
Paul Oscar.
Paul Oscar, learned counsel for the sole respondent. Let this matter be listed for admission hearing. 29 July.
Till then, Lordship, the interim prayer was there, Lordship.
IA may be disposed of since the money has been paid with the direction that the further amount may be paid regularly.
So it has already been disposed of before the learned trial court. They filed an application that has been
The
disposed of.
IA for maintenance. that
Till
I
then,
filed.
you have interim order in your favor.
Yes, Lordship.
Till
The
then-
very first day, the interim order. was
Till
disposed.
then, the interim order shall continue. In IA, heard Mr. O. Oscar, learned counsel for the applicant, also heard Mr. S.P. Chaudhary. Learned counsel for the applicant submits that this interlocutory application has become infructuous in view of the compliance by the respondent by paying the outstanding maintenance allowance to the area amount to the present applicant. In view of the submissions made by the council, this interlocutory application is disposed of on becoming infructuous.
Obligation.
May I plead your lordship, an application praying for order 41 rule 5 my lord. For stay operating part is this judgment and order dated 12/1/26 my lord. Operating part is my lord page 32 my lord. In this case, my lord, respondent number 1, my lord, file a title suit for interest of disposition of this land, my lord. That was in title suit, my lord, that is dismissed, my lord, with cost, my lord. Thereafter, my lord, respondent number 1 again file a regular first appeal, my lord. That was, my lord, remanded back, my lord. A petitioner before, yes, my lord, petitioner before this honorable court that orders, my lord. Operating party is page 32, my lord.
32 of the IA or RSA?
My lord.
What happened to the RSA?
I order not pass, my lord. That is praying for stay, my lord.
No. What happened to the RSA?
Stay, my lord. Notice was not issued, my lord. Today is first time, my lord.
RSA has not yet been admitted.
No, my lord.
Then first we have to take into consideration the RSA only. IA is to be considered after admission of the RSA. What is the operating part?
Yes, my lord. In RSA, my lord, 121 page, my lord. Same order, my lord.
The suit has been remanded back by the
My lord.
first appellate
Yes.
court.
First time title suit was dismissed, my lord, with cost, my lord.
You were the defendant
Earlier, my lord.
before the trial court.
Yes, my lord.
What is your grievance?
Sustained question of law, my lord, page 4, my lord. I have here, my lord. Whether, my lord, misread this appellant code, my lord, exhibit 3, 4, and 6, my lord. And purchase alleged in his proof alleged this purchase deed, my lord, exhibits 3 and 6, my lord. That was also not proved, my lord, in first appellant court, my lord.
No, first appellate court, whether first appellate court has decided anything.
My lord, now
It has a,
so many years that remanded back these matters, my lord. At this stage, my lord, notice may be issued and LCR may be called for, my lord.
no. What is the substantial question of law?
Yes, my lord. Substantial question of law, my lord, page 4, my lord.
Yes. First one is not substantial question of law. Misconstrued the documents. It is a question of fact. Second, where is the impugned judgment? Let us see.
Page 95, my lord.
The appellate court has not decided anything. It has only remanded back.
It is
So
approach this court only.
you are agreed with the order of remand. That cannot be a substantial question of law.
My lord, petitioner exercised this land so many years, my lord. He has possession of this land also and getting a separate patta also, my lord.
But
Now,
nothing
my
has been decided yet. It has only remanded back the case back.
My lord, again fresh procedure has been started, my lord. That's court.
An additional issue is directed to be framed. You do not have a case in second appeal.
My lord, LCR may be called for my
LCR,
admitted, my lord, at this stage, my lord.
you satisfy the court that substantial question of law is involved.
After coming this receiving LCR, my lord, I'm trying to.
No. In second appeal, before issuing notice, before calling for LCR, from records you have to satisfy that there is a substantial question of law. Only then this appeal will be admitted. You take time if you are not prepared. Otherwise, it is going to be dismissed.
My lord, before vacation, any date, my lord. 18th, my lord.
How you are aggrieved? You are not aggrieved. The trial court has dismissed the suit of the plaintiff. The first appellate court has only remanded back without making any declaration as regards right title of interest of either of the parties. You can agitate before the trial court whatever you want to agitate. What should I do?
My lord, madam, maybe again list on 18th of June, my lord. In the meantime, my lord, my concern with my senior also, my lord.
Miss El Wazida, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellant Shrimati Nazni Nara Ahmed, impugning the judgment and decree dated 12/1/2026 passed by the Court of Learned District Judge Kamrup Metro in title appeal number 7/2023, whereby the judgment and decree of the trial court was set aside and the case was remanded back to the trial court for deciding afresh after framing an additional issue as suggested by the appellate court, as well as after giving opportunity to both the sides to adduce evidence. When a pointed question was posed by this court as regards as to what substantial question of law has been involved in this case, the learned counsel for the appellant sought some time to consult some authorities and thereafter answer to the queries of this court on the next date fixed. The prayer is allowed. let this matter be listed again on
18th, my lord.
18th of June.
Oblige, your lordship.
My lord, I urge for early listing of the case. Earlier also I had filed a petition, that was IA 4045. And order was passed by the court to list it in May 2025, but despite that not listed. So I have come again.
Second petition, my lord, for
Do
early hearing.
you have
The
any
earlier
objection? The earlier order remains,
Remains.
then what
That
is
order was passed for listing in May 2025 itself, but despite not listed. And also,
We'll give you a fixed date.
yes, my lord.
Heard Mr. H.L. Moria, learned counsel for the applicant. Also heard Mr. M.K. Mishra, learned counsel for the respondent, sole respondent. This interlocutory application has been filed by the appellant for an expeditious hearing of the connected regular second appeal number 29/2023. He submits that on an earlier occasion also, the applicant/appellant had filed an interlocutory application, namely IA civil number 4045/2024, praying for early listing, and the said petition was disposed of with a direction to the registry to list the matter in the second week of May 2025. However, in spite of the said direction, the appeal could not be, it was not listed.
It was not listed.
Was not listed. Stop. Mr. M.K. Mishra, learned counsel for the respondent, does not oppose the prayer. You have no objection.
Has come, my lord. Say when except the.
LCR has already
petition
come.
is there. Say when except the repeated petition is there.
Stop.
And there are no specific, there as such ground has been mentioned in the petition.
This
LCR has already come, so I don't think that.
interlocutory application is disposed of with a direction to the registry to list the connected regular second appeal number 29/2023. 29 of 2023
Yes.
for hearing on 25th August.
25th August.
Yes.
Item 42.
May I please, your lordship? Lordship, this is for condonation of delay of 48 days in filing the RSA. So lordship, we have taken steps by speed post as well as by Dusty. While taking Dusty, the respondent number 4 has refused to accept the notice, and we have filed an affidavit to that effect. But from the tracking report that we have collected from the registry, it is seen that all the respondents have been charged, including the respondent number 4. But
Respondent number 4 has been served.
Yes, lordship. The notice has been served upon the respondent number 4.
You are appearing for?
On the respondent number 1, 2, 3, principal respondent.
These are the tracking reports that we have collected. The tracking report on respondent number 4 is that this is
Serial number?
it is in the first one, that is the serial number 1. R4 is
Mohammad Ibrahim Ali.
yes, sir.
Heard Mr. S.N. Tamuli, learned counsel for the applicant. Also heard Mr.
A.L. Mandal.
A.L. Mandal.
May pay that this delay may be condoned.
You have any objection?
Yes.
Because 48 days delay.
Yes.
Submission. The appellant obtain the certified copy, first certified copy of the appeal on 8/8/2025. And the
When is the,
appellant approves,
what is the order, impugn order dated?
implemented 9/7/2025. The impugn of judgment.
Okay. Applied on, applied or?
Applied on 14/7/2025. And obtained on 8/8/2025. And approached to the learned advocate, and advocate both for the said judgment and found some pages are missing. And
Okay.
advocate advised to the petitioner to take a fresh judgment copy of the appeal. And again, the petitioner applied for fresh copy of judgment on 26/8/2025. And that is there is a 18 days delay in between this application and obtain the second copy of appellant, but that is not explained in the convention delay of this petition.
Lordship, that is, it is clear that in the Kajis case, that we need not have to explain the day-to-day delay,
No,
but there should be some reasons for the delay.
But that does not give you a license of not explaining anything.
No, Lordship, we have explained how the delay has occurred. We have explained in our petition. Lordship, day-to-day we have not explained, but we have explained.
Why these 18 days delay?
Lordship, that 48-day delay we have explained.
Where?
Lordship,
Which where?
Lordship, in para 7. Oh, Lordship. Lordship, it will stay লিখা আছে। This is Lordship condonation of delay petition. In that petition, we have explained from in para 5 that the petitioner begs to state that upon such advice, the petitioner has again applied for a fresh copy of the judgment and decree dated 9/7/2025, passed by the learned civil judge Morigaon, Assam, in title appeal number on 26/8/2025. Thereafter, the folio and notified on 29/8/2025. Accordingly, petitioners have deposited the requisite fee on 13/8/2025. Lordship, in the earlier para, that is para 4, petitioner begs to state that upon receipt of the certified copy, that is the initial certified copy, dated of the decree dated 9/7/2025, on 8/8/2025, petitioner has approached the present set of counsels for filing the concerned connected second appeal. The engaged counsel, after going through the judgment and decree dated 9/7/2025, could observe that some pages of the judgments and the decree dated 9/7/2025, passed by the learned civil judge senior division, Morigaon, Assam, in title appeal number certain were missing, and as such, it is not possible to for the counsel to prepare the appeal on the strength of such judgment and decree. Accordingly, petitioner was advised to apply for the certified copy. Then in para 5, we have stated that the petitioner begs to state that upon such advice, the petitioners have again applied for the fresh copy of the judgment and decree dated 9/7/2025, passed by the civil judge Morigaon, Assam, in title number 7 on 26/8/2000. Thereafter, the folio was notified on 29/8/2025. So when we got the copy, first copy, we advised them to apply for the, because there were pages missing that we have an annex, and thereafter they applied for that. That is the reason we have given.
Heard Mr. S.N. Tamali, learned counsel for the applicant. Also heard Mr. A.L. Mandal, appearing for respondent number 1, 2, and 3. Stop. On perusal of the office note dated no. Continue. Learned counsel for the applicant submits that the applicant as directed by this court, tried to serve notice upon respondent number 4 by Dusty mode. However, the notice was not accepted by the respondent number 4. And to that effect, an affidavit has been filed by the present applicant narrating the said facts. Stop. Learned counsel for the applicant has further submitted that the notice issued to respondent number 4 by speed post has been duly delivered on him as appears from the postal track consignment report of notice sent through speed post to the said respondent. After going the postal track consignment report of the notice sent through speed post to the respondent number 4, this court is of considered opinion that the notice issued to the respondent number 4 has been duly served on him. This interlocutory application has been filed by the applicants praying for condonation of delay of 40 days in preferring the connected regular second appeal. By which the judgment and decree dated 9/7/2025 passed by the Court of Learned Civil Judge Senior Division Morigao in title appeal number 12/2023 is sought to be impugned. Stop. Learned counsel for the petitioner has submitted by that after passing of the decree and judgment and decree by the first appellate court in title appeal number 12/2023 on 9/7/2025 and 8/8/2025 respectively. The applicant no, in line passing of the decree and judgment and decree on 9/7/2025. Continue. 9/7 के बाद कर दी. Stop. The applicants applied for certified copy and the said certified copy was obtained by them on 8/8/2025. However, when the said certified copy was produced by the present applicant before their engaged counsel, it was found that some of the pages of the judgment in the said certified copy were missing, and accordingly, the applicant were advised to apply for a fresh certified copy. Accordingly, the applicant again applied for a fresh set of certified copies on 26/8/2025, and the same way received, and the certified copy was received by the applicants on 30/8/2025 only, and in the process a delay of 40 days has been has resulted. Stop. Learned counsel for the petitioner submits that there was no negligence on the part of the present petitioner which caused the delay, and same was caused due to the facts which were beyond the control of the petitioner. He therefore stop. Learned counsel for the petition applicant use only applicant instead of petitioner wherever petitioner. Learned counsel for the applicant therefore submits that the reasons shown by the applicants in the interlocutory application may be considered as sufficient cause and same may be condoned. On the other hand, Mr. A.L. Mondal, the learned counsel for respondent number 1, 2, and 3 has opposed the prayer for condonation of the delay on the ground that the petitioner has failed to explain the delay which has occurred in applying this for the certified copy for the second time after it was pointed out by the engaged counsel of the petitioner applicants that some pages were missing. He submits that no explanation has been given by the applicants as to why it took how many days? 18 days. 18 days for applying for fresh certificate copy for the second time after it was after it came to the notice of the applicants that some of the pages of the certificate copies are missing. Stop. I have considered the submissions made by learned counsel for both sides. Though the petitioners have not specifically explained as to what caused the petitioner to wait till 26/8/2025 after they came to know about the fact that the first set of certified copy which were obtained by them, there were some missing pages. Stop. ये लाइन पढ़ो तो last line. However, it appears that at the first instance, they filed the application for obtaining certified copy within 5 days of the passing of the impugned judgment, and as such, at the first instance, the applicant were not negligent. It is only when it was pointed out to them by the engaged counsel, by their engaged counsel, that some of the pages of the certified copy furnished to them were missing, they again applied for the certified copy for the second time. Though it is not specifically mentioned in the interlocutory application as to when the fact of missing pages in the first set of certified copy came to their notice. However, considering the fact that an application for condonation of delay has to, while considering an application for condonation of delay, a justice-oriented approach has to be taken, and in appropriate cases, same may be liberally the cause for delay may be liberally construed. This court is inclined to condone the delay of 40 days in preferring the connected appeal by the present petitioner. Accordingly, this interlocutory application is allowed and the delay of 40 days is condoned. The registry is directed to register the regular second appeal and list the same for admission hearing in the
Can it
next.
be day after tomorrow? Because the execution has started. Now today it is for orders because already the Latmon has been intimated and other stuff has been intimated. So there is a urgent need for the stay of the
If
execution. proceeding.
today it is executed,
No, today it is fixed for orders because we raised some objections. It is fixed for orders. The consideration is that and the order will be passed
when?
today. Today is fixed for orders.
When is the next date?
Lordship, next date has not been given yet because today is the date fixed. So can it be day after tomorrow?
Next Monday.
Next Monday.
Next Monday.
Much.
Let this matter be listed on 22nd June.
Much obliged.
For reasons mentioned in the judgment, this regular second appeal is dismissed.
I think
one day after tomorrow, on 17th. 17th.
I think
For reasons mentioned in the judgment, this appeal is allowed and the impugned judgment and award is set aside.
Item 3.
For reasons mentioned in this judgment, the appeal is partially allowed and the compensation awarded to the claimant is reduced to 31,72,572.
Lordship, an amount was deposited at the time of preferring appeal.
That will be refunded back.
I'm grateful.
Item 43.
Next item.
Item 44.
Please, vote. Is this is filed in connection with RSF. It is item from order passed by
Condonation of delay
delay, 58 days delay. Lordship.
will issue notice. Heard Mr. A. Sahab, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicant praying for condoning the delay of 150 days.
Only 50 days, 58.
But
Fine.
here you have mentioned 150 days.
Not 158, only 50.
In page 2 of your petition, you have wrongly mentioned. See page 2. Top.
Lordship, that 150 days was in earlier title appeal, against which we are approaching before this honorable court. In that case, title appeal was filed against dismissal of the suit.
Okay. Praying for condoning the delay of 58 days in preferring the connected regular second appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th July.
Item 45.
We have filed in petition for condoning of delay of 221 days.
What is your name?
A. Roy.
Heard Ms. Roy, learned counsel for the applicant. This application has been preferred by the applicants for condoning the delay of 221 days in preferring the connected regular second appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29 July.
Item 43.
Yes. Yes.
May I please, my lord? My lord, I am from item number 43, my lord.
Yes.
My lord, as per the last order, my lord may see the last order. In the last order, I was given an opportunity to file an press application. In the last order, my lord. Order dated 3/6/2026, my lord.
Yes.
My lord, we have filed this application on 11/6/2026, but unfortunately, this application is not being tagged, my lord.
What application?
My lord, this application I have filed under Order 41, Rule 3A. read with section 151 of the Civil Procedure Code, my lord, for the stay of the impugned judgment. My lord, what happened is there
No,
is an
before
IA.
that, there is no application for condoning the delay. In the last order,
I
it
have
is.
not delay.
Huh?
I have already filed an application for condonation of delay.
Where is it?
In the IA 1455, IA number 1455, 2026.
Okay. In this notice has been issued or not?
Yes, my lord, been issued. And accordingly, we have taken this step, my lord. The office 2026 has mentioned that neither the card or answer notice has been received in respect of the respondent number 1, 2,
No,
and
you are
3.
not audible properly.
My lord, am I audible now?
Yes.
My
Yes.
lord, if lordship may kindly see to the office note
Yes.
dated
Notice
11/6/26, my lord. Yes. Neither AD card nor answer notice have been received in respect of respondent number 1, 2, and 3 by section till date.
Yes, what is your submission?
My lord, as per the last order, my lord, I was given an opportunity to file an appropriate application. I have already filed that application, but it is not tagged today, my lord.
Will
My lord, I have filed an application and IA civil filing number is 6878 of 2026, my lord.
application under what provision?
My lord, under order 41, rule 3A,
Subclause 3.
read with section 151 of CPC.
We'll direct that to be tagged with the record.
Yes, my lord. My lord, there is an urgency. Can it be listed on 18, my lord?
Heard Mr. K. Vishwakarma, learned counsel for the applicant, who submits that in pursuant to the observation made by this court in its order dated 3/6/2026, the applicant has filed an application, interlocutory application under Order 41 Rule 3 capital A. However, same is not tagged with the instant case record. He prays for directing the registry to tag the aforesaid interlocutory application. What is the filing number?
Filing number, my lord, IA civil 6878.
6878.
2026, my lord.
With the instant interlocutory application, the prayer is allowed. Registry to list the aforesaid interlocutory application along with this interlocutory application on 18th of June 2026. List accordingly.
I'm obliged, my lord.
Yes.
Lordship, with respect to respondent number 1 and 1C, the addresses could not be located. So we therefore further 2 weeks time to collect the local addresses.
Heard, Miss, what is your name?
Escaloscar.
Escaloscar, a learned counsel for the applicant. Learned counsel for the appellant, who seeks some more time to collect, to bring on record the correct address of respondent number 1A to 1C. The prayer is allowed. Let this matter be listed again on 29th July.
May I please your lordship? My lord, there are several IAs. First IA, my lord, it was filed 9/6/21. It was filed at the instance of the appellants. Appellants were, that means respondent number 8, Sufia Khatun died. So I asked my client to collect the legal representatives of Sufia Khatun. Then they provided some names, and on the basis of those names, this 9/6/21 was filed for substitution of these persons. But later on, the opposite party says there are some wrong information. So first thing, my lord, 9/6/7 may be treated as withdraw.
9/6/7 heard. Mr. M.U. Mahmood, learned counsel for the applicant, who prays for allowing the applicants to withdraw the instant interlocutory application. The prayer is allowed. This interlocutory application is dismissed on withdrawal.
And now, lordship may kindly take 2/004/26. This substitution petition has been filed after providing the names of by the opposite party lawyer. So this, on the basis of this application, the names of legal heirs may kindly be substituted. In place of Sufia Khatun, the names of her legal heirs.
When Sufia Khatun died? When she died?
23/9. Well, that actually we have. That was in that case it was written. Now, as there is delay, so we have filed this IA, that is 2/004. On the basis of the names provided by learned friends. So this 2/004 may kindly be allowed.
No, is there delay in filing this?
Delay means, my lord, delay that we have said that because earlier it was filed by at the collections of appellants, accordingly we filed. But later on, kindly say page 6, para 2 of this petition. That the applicants back to said that during the pendency of aforesaid RSA, the respondent number 8, Muhammad Sufia Khatun died, and as per instruction of the appellants, the name of legal representatives of respondent number 8, Sufia Khatun, was sought to be substituted by substitution petition on 25/10/19. But later on, it was found that legal representatives of Sufia Khatun were not fully correct. However, later on, the details of the legal representatives were collected through the help of respondent's lawyer.
No,
and
when Sufia Khatun died? Date of death?
Exact date, my lord, we have no information. My learned friend may say.
When she died?
I'm not sure.
Here
we have explained.
In which year she died?
Oh, she died, my lord, in the year 21.
Now the substitution petition is filed in the year 2020.
Kindly say the last order was there. Last order, honorable court passed order, the instruction may be brought.
Which was?
And then again there is another order that they would provide. My learned friends, 2 friends were there, but today I have seen one. They were asked to furnish the information. So these orders are there for all these reasons. And the last time we got the full list. And thereafter, this case has been filed, which has been explained in para 2 of this IA number 2004.
No, for whatsoever reason, this substitution application has been
Yes, I know.
filed belatedly.
Related. Related means
So therefore, an application for condonation of delay would be required. Unless delay is condoned, this application can,
I understand that.
and the appeal has also abated against
Respondent number 8.
respondent number 8, whether abatement has been set aside or not. So
No.
that is also required.
Automatically, after 60 days, it has been abated.
So unless there is a prayer for setting aside
Then
abatement.
another IS have to file. Kindly fix next week. Well, I will file another IA for condonation of delay.
As well as for setting aside abatement.
Abatement, yes.
In RSA. Heard Mr. M.U. Mahmood, learned counsel for the appellant. Also heard Mr. M.K. Chaudhary, learned counsel appearing for all the respondent except respondent number 8. Learned counsel for the appellant submits that though the names of legal heirs of respondent number 8 were correctly furnished by the respondents belatedly, and though the present appellants have also filed an interlocutory application for substituting the legal heirs of deceased respondent number 8. However, the appellant requests to file appropriate application for setting aside the abatement of appeal against respondent number 8, as well as for condoning the delay in filing the said applications. Hence, learned counsel prays for some more time to take appropriate steps in this regards. The prayer is allowed. Let this matter be listed when?
Next week, my lord. Because all matter.
24th June.
My lord, there is another IA. That is, my lord, IA number 286019. So we have filed that for stay of the judgment passed by the learned judge.
What happened?
Till disposal of this.
What happened to RSA?
That RSA, my lord, RSA, there is.
RSA has been admitted or not?
I think it is admitted because substantial questions have been framed on, and let's see the order dated. Order dated 27/8/18 in RSA.
Since 18,
27.
there is no stay.
No,
on various occasions, actually, our senior friend had pressed this. It was considered by many different benches and it was not granted actually.
No, it is technical.
We'll stay if the substantial question of law has been.
Appeal has been admitted, my lord.
Yes.
Appeal has been admitted on 27/8/18. After admission, substantial questions.
And you have filed execution case also. Have you filed execution case?
So that I'm not sure, and I think we have not filed because since that nothing has happened as such. And secondly, the interim prayer which they're asking, I mean the stay of which they're asking, that schedule of land, they themselves in their evidence have said that it's not in their possession. So what stay for what? That's also one thing.
My lord, as the appeal has been admitted.
What is the decree? Confirmation.
Then if the matter is coming up very soon, Lordship will consider on that day because I am also not prepared to that extent.
Okay, then we'll take it up on the next day.
If on 24th.
They have not filed execution case.
They have not filed.
Not filed this.
So that may be kindly observed till the disposal of this appeal, execution proceeding may not be
May not be filed.
proceeded. That may be proceeded because otherwise the purpose of filing the SRS would be futile exercise.
Sir, something which is not even filed, how?
No. It is filed. It is aforesaid file. That is numbered also.
We'll take up this on the next day.
Next day.
Lordship, I'll also be.
Release this interlocutory application IA 28
On that day, the stay matter may also be considered. Yes.
along with the interlocutory application, along with the connected IA, along with the connected regular second appeal on 24th June.
There should be, I think, two, setting aside the abatement order as well as condonation of delay. Two separate petitions would be required.
Yes, that you have to decide.
Obliged, madam.
Item 55.
May it please your lordship. Lordship, White order dated 15/5/26, the Honorable High Court was pleased to allow this petitioner to file an affidavit for serving this notice via WhatsApp to the respondent.
WhatsApp?
Yes. Lordship, and to that effect, we have filed an affidavit which is on record. And the notice was duly served on WhatsApp showing blue tick marks therein. A color printout of the screenshot has been annexed.
What is the rule which shows that when blue tick marks are shown, it can be presumed served? Is there any such rule?
That is the normal WhatsApp function.
No, is there any rule regarding when to presume service? What is the rule relating to notice to be issued
that has to be
electronically?
That has to be seen, Lordship. We were complying the order of this Honorable High Court, and apart from that, speed post service was also directed, which we have taken. In the 3 addresses mentioned in the cause title, only one came back as unserved. The remaining 2 reports are still not have not still not.
When have you taken steps?
We have taken steps on
When?
On 19/5/26. And the affidavit was filed on 11/6/26.
Mr. On next date, you come prepared with the
Regarding service.
service through electronic mode. What is the law? Heard Mr. H. Talukdar, learned counsel for the petitioner, who submits that in pursuant to the order of this court dated 5/15/2026, the petitioner has filed an affidavit regarding service of notice in service of notice to the sole respondent through electronic mode. When a query was posed as to what is the law with regard to service of notice through electronic mode, and when and under what circumstances notice may be deemed to be duly served, the learned counsel for the petitioner sought some time to answer to the queries. Prayer is allowed. It also appears that on 19 learned counsel for the petitioner has further submitted that on 19/6/2026, the petitioner has also taken steps for issuance of notice upon the respondents by speed post at 3 known addresses of the respondent and only one notice has returned without service. He submits that with regard to other 2 addresses, service report is still awaited. In view of the above, the registry is directed to place the postal track consignment report of the notice sent to respondent in remaining 2 addresses before by speed post before this court on the next date fixed. Let this matter be decided 17th of July.
May it please your lordship.
Yes.
Lordship, here the petitioner has filed a title suit for speed under a specific performance act, lordship. Herein, the decree was passed ex parte, lordship. The decree was for declaring the agreement dated 27/5/2019 to be legal binding upon the respondent and specific of contact and recovery of cash position of the suit land and permanent injunction. In this suit, lordship, although the judgment was passed, lordship, the recovery of cash position was not passed, lordship. Not included in the judgment, lordship. The judgment is as, lordship, page 22 annexure 2, lordship.
Ex parte judgment.
Ex parte judgment.
Yes.
Lordship, thereupon, lordship, when they came to for the execution part, lordship, they came to notice that this portion was not included in the judgment, lordship. If they filed a petition on 14th May 2025. Lordship.
Petition under what provision?
Lordship, that petition is at page 3, lordship. That petition is for including for making
Where is that petition?
lordship, petition is at annexure 3, page 35. Lordship.
No, by the ex parte judgment, what relief was granted?
Lordship, the relief, lordship, at page 29 is the operative portion, lordship. Order, page 29.
Okay. Where is your petition?
Then is at page 35, annexure 3.
Under 151
151.
or
Or Lordship, the prayer is at page 36, Lordship. It is therefore prayed that your honorable court would be pleased to accept a petition, and after going through it, it be pleased to include the recovery of cash position.
thereafter what order was passed?
Lordship, this was rejected, Lordship. That is at page 38, annexure 4, Lordship. Lordship, the operative portion, page 39, Lordship.
Yes.
Lordship, the last part, but in the absence of even if, last part, Lordship, even if last paragraph, Lordship, even if the relief of recovery of position or declaration that any other deed of agreement of sale as void were not expressly granted in the order portion of the judgment or in the decree, if it is decided in the body of the judgment, then also the said relief could have been inserted in the decree under section 152 CRPC. But in absence of any such discussion, decision, and such new relief cannot be inserted by way of correction of the decree of judgment. Lordship, it was opined that some new relief has been called for. But Lordship, in our plaint, Lordship, it is clear that we had in our plaint, Lordship, page 19, Lordship. The prayer portion, we have clearly said para 4, Lordship, page 19, Lordship.
Yes.
Lordship, the prayer in page number 19, Lordship, that prayer 4, Lordship, that if the defendant declined to obey the order of decree of the court for execution of the sale deed in favor of the plaintiff, then this honorable court or prohibit commissioners acting in for and on behalf of the defendant execute the sale deed in favor of the plaintiff through sub-register Jorhat, Assam in connection with the suit and put the plaintiff in cash position of the suit. Lordship, this is not a new ground. And
No. The trial court has said that in the ex parte judgment,
yes,
while decreeing the suit, it has not discussed about this relief. Therefore, in exercise of powers under section 152, it cannot do so. Appropriate relief is perhaps before the appellate court.
Lordship, the discussion part, Lordship, page 22, the first paragraph of the annexure 2, Lordship.
Page
22, Lordship. Annexure 2, Lordship. Lordship, the suit is for declaration and specific preference of permanent and recovery of cash position as well as for permanent and injunction, Lordship. Here, the court has taken a view, Lordship, that the suit is for recovery of cash position in specific performance of the contract, Lordship, and in points of determination, Lordship.
Now you read the impugn order. Read the impugn completely. Page 38. Read loudly.
So, I petition that this plaintiff has prayed to correct the judgment and decree by including the relief, Lordship, recovery of cash position, declaration that if the agreement, deed, or writing executed by the defendant in favor of other third persons in respect of the suit property are before filing of the present suit or after filing of the present suit and during its pendency shall be treated as bond.
Where are you reading?
Page 38.
38.
The last part actually defines that why the opinion has been taken that these are reliefs, new reliefs we have sought for, Lordship. But these are not new reliefs, Lordship. The
In the plaint, we have mentioned that khas position, we have prayed for the khas position. And in the judgment, Lordship,
No,
there are
Mr. Sharma, what I am asking you to read the impugn judgment, impugn order completely.
from page 38, Lordship.
Yes.
Plaintiff represented today is fixed for order on petition number dismiss, 5 petition number dismiss 151 of the CRPC. Plaintiff side has prayed to correct the judgment and decree by including the relief of recovery of cash position and declaring that if any agreement and deed or writing executed by the defendant in favor of the other third person, persons in respect of the suit property either before filing of the present suit or after filing of the present suit and during its pendency shall be treated as void ab initio, is a nullity in such is liable to be cancelled. Pursuant to the concerned judgment and decree dated dismiss. Considering the judgment as well as the decree, it has been seen that the court has not decided or passed any judicial pronouncements on matter of recovery of position lodge. Apart from that, there was no decision regarding any other deed of agreement for sale of the suit land lodge. In absence of such discussion or decision on judicial side, new reliefs cannot be inserted in the judgment and or decree under section 151 of CRPC.
Yes.
So my point is that while rejecting my prayer, Lordship, if it was opined that, but in absence of such discussion or decision, such new reliefs cannot be inserted, Lordship. My point is that these are not new reliefs, Lordship, because in the plaint, Lordship, I has made the prayer, Lordship, and in the judgment also, Lordship. In the judgment, Lordship, point of determination, Lordship. Here issues were not framed since ex parte judgment, Lordship. Page 26, Lordship. Page 26. Point for determination, Lordship. Whether the plaintiff was ready and willing to perform his part of the contract, Lordship. Whether the plaintiff is entitled to relief as prayed for, Lordship.
Yes. Yes, what is your submission?
My submission is that I have, since the point of determination, Lordship, whether the plaintiff is entitled to the relief as prayed for, Lordship. Non-inclusion of the recovery of cash position, Lordship. I will not be able to enjoy the fruits of my trees, Lordship. And Lordship, and as to say, Lordship, non-discussion, Lordship, on the first para itself, Lordship, it has been noted down that the suit is for declaration specific performance of contract and recovery of cash position. And in the plaint also it is there, and the am I entitled to the reliefs as in the prayers? Lordship, since the cash position is in my plaint, Lordship, Lordship, this is not a new relief I have sought for. It is only due to the omission part, Lordship. I have filed a petition for including that part, Lordship.
Yes, Mr. Mahant.
My lord, his petition is for what? His petition is for my lord correction of the my lord. The lordship kindly see the petition, my lord, page 35, my lord. The plaintiff above named responsibly swear that the plaintiff has instituted the above mentioned title suit against the above named defendant before the honorable court. Accordingly, honorable court disposed of the case by passing in judgment and decree set 2011-2023. And learned advocate of the plaintiff and going through the case record is filing execution case before the honorable court. It was found that probably due to some topographical mistake, the judgment was passed without touching the necessary pair portion of the plaintiff and hence that they had not gone into the relief recovered by the cash possession.
The suit is the plaintiff was specific performance of contract is and a type of class it is a sale deed executed either by the seller or by the honorable court in favor of the plaintiff, then the such circumstance the possession of the said suit land upon the strength of the sale deed and the judgment and decree must for the plaintiff, and hence the present plaintiff filed the recently said by inputting the said recovery of khas possession into the judgment and decree by above mentioned suit, and if the required the said judgment and decree may be amended accordingly, and accordingly the said end of justice as well for the end of trial also. The purpose of the petition is bona fide for the interest of the plaintiff. Therefore, paid that the honorable court will be pleased to accept the petition for going through it by pleasing please include the recovery of first person and declaring if any agreement that we in writing did or writing execution by the defendant in favor of any other third person in interest of the said so. So they want to incorporate this, my lord, is amounting to, my lord, review of the judgment, my lord. It's a good ground for maybe for case, my lord, for appeal, my lord. But in 151 petition, my lord, that cannot be done, my lord, in a shortcut method, my lord. Because your lordship can only see what he wants. He says that one hand he says it's a clerical mistake, other hand he want to put some pair, my lord. And here, then, my lord, your lordship can only see very rightly, my lord, by the learned trial court, it was, my lord, pass the order, my lord. There is, because he want to insert something, my lord, some pair. That cannot be done, my lord. It is not a clerical mistake, my lord. Because there is no discussion on that point also. That is rightly pointed out by the learned trial court. And even, my lord, petition for correction under 152, my lord, not 151. But it is that in such situation, my lord, I have seen, my lord, in many cases, my lord, even I also filed, my lord, I will file in very immediately, my lord.
What is the period of limitation for filing 152 petition?
152 petition.
Is there any limitation? Because in this case, the judgment was passed in the year 23.
But it was in 25 probably.
The
file
correction was sought in the year 25.
25.
So is there any period of limitation?
At that point, I have not gone through, my lord. For clarification. Limitation.
Any other point?
That is the learned trial court, my lord, rightly passed the order, my lord, and my lord, there is nothing to interfere with, my lord. Because, my lord, of course, he has a very good ground for appeal, my lord. He can everything, my lord. But by way of correction, my lord, that cannot be, my lord. A pair cannot be in charge. And, my lord, when there is a specific, there is a judgment of the 2026, my lord. When there is a specific provision, that cannot be ignored, my lord. This is a recent judgment, my lord, 2026, my lord.
Yeah.
Para 7.2 and 7.3.
What it says?
The limits of the inherent power under section 151 Code of Civil Procedure can also are also not longer res iptiga. In Padma, Sen versus State of Uttar Pradesh, year 1961, the court held that the inherent power cannot be exercised in a manner inconsistent with the express provision of the code, or in other words, that the inherent power have also exercised that due respect to the other provision of the code, my lord. So you had, my lord, in well, he can, my lord, delay may be condemned, my lord, he can well here by the file an appeal, my lord.
Or whether he could have filed a review.
Review, my lord. Best way was review, my lord. Review, for review, there is a limitation 30 days, but in an appeal limitation. So that was not done, my lord, by way of, my lord, your lordship. Because yes, I have seen some of the cases, my lord, that is specific performance contact, my lord, recovery of possession, my lord, no discussion made, my lord. I filed in appeal, man, in appeal it was allowed.
Yes, Mr. Sharma.
He can, my lord, pay for a, my lord, condemn, even if there is a delay, my lord.
Relief as sought for lordship cannot be.
But it cannot be a clerical mistake, man.
I rely on his judgment.
What it says. Para,
There are 18 lordship.
what it says.
Lordship, it says that separate relief if opposition and partition of separate position, lordship, not needed, lordship, it will go on a multiplicity of multiplicity of proceedings, lordship.
Heard Mr. S. J. Sharma, learned counsel for the petitioner. Also heard Mr. T. J. Mohanto, the learned senior counsel assisted by Ms. P. Bhattacharya, learned counsel for the respondent. This application under Article 227 of the Constitution of India has been filed by the petitioner, impugning the order dated 8/9/2025 passed by the Court of London, Civil Judge, Senior Division, Jorhat, in title suit number 82/2022, whereby the trial court declined to correct the judgment and decree by including the relief as prayed for by the present petitioner in his application under section 151 of the Code of Civil Procedure, which was registered as petition number 1189/2025. The facts relevant for consideration of the instant revision petition, in brief, are that the present petitioner had filed a suit for specific performance suit under the provisions of specific performance of contract, seeking reliefs of specific performance of contract within bracket agreement dated 27/5/2019, executed between the plaintiff and the present respondent for sale of land fully described in schedule to the plain. Apart from the aforesaid relief, the relief of permanent injunction, recovery of cast possession, and declaring that if any agreement, deed, or writing executed by the defendant in favor of any other third person in respect of this suit property, either before filing of the title suit or after the said filing, shall be treated as void ab initio. The aforesaid suit was registered as title suit number 82/2022 before the Court of Learned Civil Judge Gauhati. Stop. The said suit proceeded ex parte against the present petitioner, and by judgment dated 6/11/2023, the suit was declared ex parte against the present respondent. Not 6/11, 2011-2022, 2011-2023. By the aforesaid decree, it was held by the trial court that the plaintiff is entitled for specific performance of contract for sale of suit land in terms of agreement dated 27/5/2019, subject to payment of remaining consideration amount of rupees 2,27,000 to the defendant within 3 months from the date of the judgment. And on receipt of such balance amount, the present respondent was directed to execute a registered sale deed in respect of in favor of the present petitioner in respect of the suit property. It was further directed that in the event of failure on the part of the defendant to execute the deed after receiving the remaining amount of rupees 2,27,000, the plaintiff would be entitled to get the deed executed through the process of the court by depositing the amount in the court. Apart from the aforesaid relief, a permanent injunction was also granted against the present respondent within bracket defendant from transferring the suit property to third party till execution of the sale deed in favor of the plaintiff. Stop. The learned counsel for the petitioner, Mr. S.J. Sharma, the learned counsel for the petitioner, submits that at the time of execution of the ex parte decree passed in favor of the present petitioner, it came to the notice of the present petitioner that the trial court has not included two reliefs which were prayed for by the present petitioner in his plaint, namely number one, recovery of khas possession, number two, a declaration to the effect that if any agreement, deed or writing executed by defendant in favor of any other third person in respect of suit property, either before filing of the present suit or after filing of the present suit and during its pendency, shall be treated as void ab initio and shall be a nullity as such, which is liable to cancel. He submits that after noticing the aforesaid omission from the judgment and decree which was passed in favor of the present petitioner, he approached the trial court again on 14th of May 2025 by filing an application under section 151 of the Code of Civil Procedure, pointing out about the omission made by the trial court in the judgment and decree, in the ex parte judgment and decree passed in favor of the present petitioner. He submits, the learned counsel for the petitioner submits that though the petitioner pointed out that said omission might have been done by the trial court due to some typographical mistake or unintentional omission. However, by the impugned order dated 8/9/2025, the trial court rejected his prayer for inclusion of the reliefs which were excluded in the ex parte judgment and decree on the ground that it would amount to incorporating new reliefs in the judgment as no discussion or decision on judicial side was made on the aforesaid reliefs. Learned counsel for the petitioner submits that the relief sought for by the petitioner in his petition filed under section 151C of the Code of Civil Procedure may not be regarded as new reliefs, as same were categorically stated in the plaint filed by the present petitioner. He submits that even in the impugned judgment, in paragraph 1, the trial court also mentioned that the suit is for declaration of specific performance of contract, recovery of khas possession, and for permanent injunction. However, it omitted to add the relief of recovery of khas for possession and declaration regarding any agreement or deed or writing executed by defendant during the pendency of the suit to be treated as void ab initio. He submits that the trial court, in the impugn order, has erred in holding that relief sought to be incorporated, relief which was prayed to be incorporated by filing the application under section 151 of CPC are new relief. He submits that it is a settled law that in a suit for specific performance of contract under specific relief act, in appropriate cases, where the plaintiff seeks the relief of recovery of possession, such relief should be granted. Otherwise, it would result into multiplicity of suit. He therefore prays for setting aside the impugn order passed by the trial court and directing the trial court to incorporate the relief which is prayed for by the present petitioner. Stop. On the other hand, learned senior counsel for the respondent has submitted that the trial court has rightly rejected the application for incorporation of reliefs which were not granted in the ex parte judgment by the trial court by exercising its powers under 151 CPC. He submits that even an application for, he submits that the trial court was correct in holding that since there was no discussion or decision as regards the entitlement of the reliefs which the petitioner is seeking, which the petitioner is praying for incorporating in the judgment, in the ex parte judgment now, where Abhishek a line par dena. Lastly, hence, same cannot be regarded as a mere typographical error which can be rectified by exercising powers under section 152 or 151 of the CPC. He submits that the correct approach would have been either to file a review application or to prefer an appeal. And in both the cases, he submits that the law of limitation would have been applicable. However, in the instant case, the petitioner approached the trial court after about more than 2 years of passing of the ex parte judgment for incorporating the reliefs which were omitted by the trial court. He submits that when the petitioner could have approached by filing a review application or an appeal against the ex parte judgment for omitting the reliefs claimed by the petitioner in his plaint. Hence, the inherent power of the court cannot be exercised in such cases under section 151 of the Code of Civil Procedure. He submits that exercising inherent power under such circumstances would be inconsistent with the express provision of the code. He submits that the exercise of inherent power has to be made with due respect to the other provision of the code. They exist to supplement the procedure, not to override it. In support of his submission, he has cited a ruling of the Apex Court in the case of Reliance General Insurance Limited versus Kanika and others, reported in Manu/SC/0184/2026. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. It appears that though the petitioner, as plaintiff, in the plaint filed by him in the title suit number 82/22, has prayed for reliefs of recovery of khas possession of the suit land after execution of the sale deed, as well as also for a declaration that any agreement executed, any agreement/deed/writing executed by the defendant either prior to filing of the suit or after filing of the suit or during the pendency of the suit to be treated as void ab initio. However, the trial court in its judgment dated 2011-2023 passed in the title suit number 82/2022 has not made any discussion in respect of the said reliefs, neither granted any such relief as was prayed for. Hence, This cannot be regarded as a mere typographical error which may be agitated by filing an application under section 151 CPC. The petitioner could have approached the trial court either by filing a review application or by preferring an appeal against the ex parte judgment dated 20/11/2023, and in which case the law of limitation would have been made applicable to the said review petition / appeal. This court does not find any error in the observation made by the trial court that since there is no discussion or decision on judicial side in the ex parte judgment dated 20/11/2023 regarding the reliefs which were not granted to the petitioner by the said judgment, same cannot be rectified under section 151 of CPC. The observation of the trial court that the section 152 of CPC may also not be taken recourse to, as same is to be utilized only in case of a correction of arithmetical error or errors arising out of accidental slips or an omission. Stop. In view of the discussions made and reasons stated in the foregoing paragraphs, this court does not find this case to be an appropriate case where inherent jurisdiction of where supervisory jurisdiction of this court under Article 227 may be invoked by interfering in the impugned order. Accordingly, this revision petition is dismissed. Parties to bear their own cost. Disseminate. 51.
On behalf of DNAT, respondent 1.
Litigants there listed as none has appeared for the petitioner or the respondent in criminal petition number 388/2023. However, since the learned counsel were heard at length, let this case be listed for delivery of judgment. On 24th June, in regard to, you are only in contempt case.
Yes.
Contempt case also. None has appeared for the petitioner on call. Heard Miss, what is her name?
D. Sharma,
D. Sharma,
on behalf of D.
appearing on behalf of Mr. D. Nath for respondent number for whom you are
Only number 1.
for respondent number 1. Since this contempt case was tagged with the connected criminal petition number 388 only to facilitate the consideration of the said criminal petition, and since said criminal petition, after delivery of the judgment of the said criminal petition, this contempt petition may be detached from the said criminal petition and listed before appropriate bench. After the 24th, it will go back to the original bench. List accordingly on 24th June.
Diploma.
Under order 41, item 12.
My pleasure, Lordship. My lord, here the plaintiffs are the heirs of the original Patadar, that is the Manohar Buddhakar and Saradabala Buddhakar. They are the original owner of the land, having the Khatian in their names. After the death of their heirs were brought on record, and thereafter their grandchildren are the Khatian holder of the said land. They have paid the revenue to the government, so in respect of the Khatian. And last time when they went to deposit the rent, land revenue, the Tahsildar refused to accept as the land has become khas. Because it is under Gwalpara Tenancy Act. The Khatian holder is a landholder. And these two persons, Manohar Buddhakar and Sarobala Buddhakar, they are the Khatian holder of the land. Therefore, the name of their heirs cannot be taken out from the Khatian, and the land cannot be made khas, that is the government land. Against that order, the plaintiffs have filed the suit for declaration of right title interest of the Schedule A and Schedule B land. The landed, the government, the state of Assam and its various officers were implicated as defendant, but neither the state government nor its officer have entered appearance, nor filed their written statement, nor cross-examined our witness. Moreover, we have examined the government officer, that is the circle officer.
What suit was dismissed? Suit.
Yeah. My suit was dismissed on the ground that the suit is barred under Section 154 of the Assam Land and Revenue Regulation.
Okay.
That the finding of the trial court is this, as it is barred under Section 154, so we preferred an appeal before the appellate court, that is the Civil Judge Senior Division Dhubri. Learned civil judge also fell into the same error and holding that the my suit is barred by under Section 154, 1A and C of the Land Revenue Regulation. That is, your lordship will get at page 44. Page 44, discussion and reasons thereof. After going through the plaintiff and designed the pleading, the Schedule A and B as described in the plaint was acquired by the state government. However, the said fact.
What is 154 1A and C?
Alright. Schedule A and B, that is the land.
No, 154 1.
Oh, 154 is.
Assam Land and Revenue Regulation.
Section 154. ACM 1AC. But the Section 154 Land and Revenue Regulation matters exempted from the cognizance of the civil code. Except when otherwise expressly provided in this regulation or rules issued under the regulation, no civil court shall exercise the jurisdiction of any of the following. The question as to the validity or effect of the settlement, or as to whether the conditions of any settlement are still in force. B, the question of the amount of revenue tax. C, the formation of record of rights, or the preparation, signing, or alteration of any document contained therein. Therefore, my contention is this, my lord. We are the owner and title holder of the Schedule A and Schedule B land. When we came to know that the land has become khas, then we filed the suit. Because khas means it has become government land. That is without any notice, nothing. Therefore, my title over the land has been questioned, has gone. Therefore, it is my duty to file a suit for declaration of right title interest in respect of that land. Therefore, under the Gauhati Tenancy Act and here in this Assam, there are two different acts there. Under the Gauhati Tenancy Act, the khatian holder is the patta holder. And my khatian cannot be cancelled. And it cannot be cancelled, and land cannot be made khas. Therefore, the learned Lower Appellate Court held that the my suit is barred under section 153 A and C. I have already read the one in A and C. That is, that is not applicable so far my case is concerned. And moreover, it is a very interesting, my lord. The page 45 top. I am not blaming the civil judge senior division, Thubri. See, the learned court has referred two decisions. One is State of Assam versus Abdul Noor, 2004 JLR Assam. Government acquired the land of untenable. And Muslim Mandal versus State of Assam, 2013. It has been held at the Guwahati High Court that the civil court jurisdiction is exclusively matter arising under the specific land statute like acquisition or settlement land. But I have I try to find out this case decision. This decision is not available, number one. State of Assam versus Abdul Noor. It is not available. And somehow I got the Muslim Mandal and the State of Assam, and I got the copy of that. Your Lordship is very interesting. This is relating to the Foreigners Act.
Citation tallies. Citation tally.
Second is right. Tallies. 2013 3 JLR 402.
Now, what substantial question of law?
My only one substantial question of law. Whether my suit is barred by limitation. Whether my suit is barred under section, that is at first 4. But the government has not filed written statement. Government has not adduced evidence. Government has not cross-examined the plaintiff. Now at the administration state, government cannot say anything.
But still they can say.
No, it is not a 226 petition.
Oh,
It's an appeal.
But you have to satisfy the court that substantial question of law.
I am satisfied. That is the section 154. Section 154 is the civil court jurisdiction, but under section 154. But so far my case, my facts of my case is concerned, it is not covered under section 154 of the, because my land is a Khatian land. My land has become khas. That is the government land. Therefore, it is the plaintiff has got a right to declare the right title interest over the land, And
Okay.
for that purpose,
We
the
are-
section 154 will not come.
Heard Mr. A.C. Sharma, the learned senior counsel assisted by G. Bhardwaj, learned counsel for the appellant. Also heard Mr. T.R. Gogoi, learned counsel appearing for respondent number 1 on after considering the materials on record as well as after hearing learned counsel for the appellant, following substantial question of law is formulated in this appeal, whether the first appellate court committed perversity in holding that the suit, in arriving at conclusion that the suit filed by the present appellant is barred under section 154 of the Assam Land and Revenue Regulation 1886. Issue notice to the respondents. Since Mr. T.R. Gogoi has appeared for respondent number 1, no formal notice need to be issued to the said respondent. The appellant shall take steps for issuance of notice upon the remaining respondents by speed post as well as by usual mode within. Who are these 2, 3, and 4?
Other legal years of the
They are pro forma.
They are pro forma. They do not want to join, but they are the owner of the land.
Through speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th of July. Let the records of the trial court as well as first appellate court be requisitioned. The registrar shall take steps for requisitioning the records. Let also, now the appellant is also directed to furnish a copy of memo of appeal along with annexures to Mr. T.R. Gogoi within 2 days from the date of this order, list accordingly. Muslim bundle, you can take it back.
All right.
You can take Muslim bundle back.
Oh,
So return করে দিব। Think
The present appellant before your lordship was the defendant number 1 in the suit, your lordship. The suit was dismissed and it was reversed in appeal, your lordship. In appeals, it was decreed, your lordship. The
suit was
dismissed. Initially, it was
for what relief?
lordship, just the brief facts, your lordship. The defendant number 1 purchased the suit property by the registered sale deed on 25/9/2023. Thereafter, there was a field mutation in 2024 and a proper mutation, regular mutation case was also filed. Subsequently, what happened, your lordship? The plaintiffs filed the suit in 2006, your lordship, claiming that they have purchased the suit land from my vendor in 1985.
When you purchased?
In 2003, your lordship.
Okay.
There was a mutation also in 2004. And in 2006, the suit was filed claiming that they are the owners purchasing the suit land from my vendor in 1985. And my vendor was also made defendant number 2, your lordship. And the vendor filed his WS stating that he did not sell the suit land to the plaintiffs, your lordship. There was a registered sale deed. They have produced a registered sale deed. But the defendant number 2 stated that it was not the same suit land, your lordship. The suit was dismissed because the plaintiffs could not prove that by way of evidence that the same suit land is the land which the defendant number 1 is occupying. Because in evidence, the PWs miserably failed to show the exact amount of land that is under their possession and the other details relating to the suit land, your lordship. Thereafter, they preferred an appeal. In the appeal, it was decreed on the presumption that since there is a registered sale deed prior in time, your lordship, and there is a strong presumption in favor of a registered sale deed, as such, a subsequent sale deed cannot be treated as a valid sale deed and it has to go. The learned appellate court did not go into the factum of possession as well, because immediately after my purchase in 2003, there was a field mutation. There was a DW3, the Gauhati also deposed that while purchasing the suit land, it was also delivered, the possession was delivered in my favor. The plaintiffs asserted that after initial purchase in 1985, they did not mutate it for some reason, and it continued to be in the name of the vendor. From 85 to 2003. Thereafter, the vendor again sold the property to the defendant number 1 in 2003. That was the stand of the claim.
The schedule tally.
The
schedule of both the
schedule tallies, your lordship.
Of both the deeds.
Both the schedule tallies.
Then how the suit lands are different?
Lordship, there are 2 suit lands, your lordship. There is one suit land, but the schedule of the previous deed contains a bigger plot of land, your lordship. 2 dags and 2 separate dags and pattas, your lordship.
Answer.
One in the subsequent deed, there is only one portion of it.
So
And in evidence also, your lordship, the plaintiffs could not assert what was their portion of land, what was the measurement of their land, and what was the boundary. They could not, they failed to depose.
what is the substantial question of law?
The substantial question of law that we are proposing, your lordship, regarding the issues, your lordship, if your lordship comes to the issues.
Come to directly substantial.
Substantial question of law. One of the substantial question of law proposed is on the possession, your lordship. Even if we assume that the schedule tallies, your lordship, the substantial question of law on at number 2, your lordship, whether the reversal of the decision on the issue number 5 as regards to possession of the defendant over the suit land before filing the suit justified, more so considering the uncontroverted evidence of the Gauhati and the
What was the issue in this regard?
The issue number 5, your lordship, is whether the plaintiffs have right title and possession or the defendant was in possession over the suit land.
It was held.
It was held that the defendant was in possession, that the plaintiff was in possession. My possession was not considered, your lordship.
Now who is in
I am
possession?
in possession. Because the Gauhati has deposed as DW3 that at the time of registration of the sale deed, the suit land was delivered, the vendor delivered the possession in 2003 to the defendant number 1.
What relief the plaintiff were seeking?
They were seeking cancellation of my sale deed as well.
And what else?
And
Consequential relief.
the prayer portion is at page 17, your lordship. Declaration declaring the sale deed number so and so in favor of the defendant number 1 is void. Decree of permanent injunction against the defendant, restraining them from disturbing the force or taking forceful possession from. They are saying it is under their possession. Decree of precept to be issued for passing the after passing the decree for cancellation of the sale deed.
The injunction, declaration, and cancellation.
Cancellation.
No recovery of possession.
No recovery of possession.
So only as regards possession, the
Uh,
appellate
lordship,
court went wrong.
went wrong. Also, as regards the issue number 3, your lordship, the appellate court went on to hold that since there is a registered sale deed, appellate court did not go into the evidence of the parties as to whether they could prove what was the actual measurement of the land or else. Appellate court held that since there is a registered sale deed in their favor, as such there is a strong presumption as to the existence of the sale deed, and hence the second sale deed could not have been executed by the vendor. In this regard, your lordship, the appellate court did not consider the fact that the presumption is as regards to the existence of the sale deed only and not as regards to the contents of the sale deed, as to what was the exact land and what was the land under the previous sale deed.
So only substantial question of law may be
And
regarding perversity,
perversity
no other.
and the possession as well. Substantial question number 2 as regards the possession, and 4, not 4. 4 or 5, your lordship, but either would suffice, your lordship, as regards perversity.
Heard Mr. S.B. Mukherjee, learned counsel for the, B.J. Mukherjee, learned counsel for the appellant. This appeal has been preferred by the appellant Shri Rajesh Rai, impugning the judgment and decree dated 24/2/2026, passed by the Court of Learned Civil Judge Senior Division, Nagaon, in the title appeal number 3/2024, whereby the judgment and decree dated 19/12/2023 passed by the Trial Court of Civil Judge Junior Division Number 1 in title suit number 178/2012 was set aside and reversed, and the appeal was allowed. After considering the submissions made by learned counsel for the appellant and after going through the materials available on record, following substantial question of law is formulated in this appeal: whether the judgment of First Appellate Court in whereby it reversed the decision of the trial court is hit by perversity, and whether it arrived at a decision as regards possession of the suit land in favor of the in whose favor arrived at lastly. Possession of the suit land. Possession of the suit land in favor of the contiguous. Possession of the suit land without there being any evidence on record to substantiate the same. Issue notice to the respondents and call for the records of trial court as well as First Appellate Court. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30 July. The registry shall take steps for requisitioning the aforesaid records. This appeal is admitted. List accordingly.
Lordship, liberty to urge other substantial question of law at the time of hearing so arises.
That is their statutory provision is there.
Much obliged.
Item 15.
Lordship, the leading counsel of the appellant is unavailable today. So I'm praying that the matter may be passed over for the
Heard, Mr. What is your name?
S. Bhattacharya.
S. Bhattacharya, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed on 20 July.
20. 20.
Item 16.
Plus, plus.
Lordship, this is an appeal, a regular second appeal against an order by which the appeal was dismissed as a consequence of non-condonation of delay, Your Lordship. This decree was ex parte against the defendants, and when the execution case was filed, they preferred an appeal, which was delayed by 211 days. There was explanation. The delay condonation petition is at page 27 onwards, at annexure enclosure 2, Your Lordship. And delay was not condoned because for a period of time, a specified period of time from the date of knowledge, I'll take your lordship to the exact order, your lordship. The order of this order is at page 31, your lordship. Order dated 22/2026, your lordship. At paragraph 8, your lordship.
Yes, read it.
Even assuming the knowledge of the petitioner's appellants from the judgment and decree passed in TS number so and so to be from 24/9/2024, the petitioner's appellants have failed to explain the delay from the date till filing of the appeal in April 2025. From September 24 to April 2025, there was no explanation of delay, your lordship.
Was there any
And the
explanation?
ground urged was that the advocate did not communicate. The advocate was entrusted. There was no WS as well. No WS was filed on our behalf, and it proceeded ex parte, your lordship.
Mr. B.J. Mukherjee, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure has been filed by the appellants impugning the order dated 22/2026 passed in title appeal number 9/2025, whereby by the Court of Learned Civil Justice Senior Division Bongaigaon, whereby the said appeal was dismissed on being barred by limitation as a consequence of dismissal of petition number 1322/2025 filed by the present appellant under section 5 of the Limitation Act, praying for condonation of delay in preferring the connected title appeal number 9/2025. After considering the submissions made by learned counsel for the appellant and after going through the materials available on record, following substantial question of law is formulated in this appeal. Whether the order dated 22/2026 passed by the Court of Learned Civil Justice Senior Division Bongaigaon in title appeal number 9/2025 is hit by perversity. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30 July. Let also the records of the first appellate court and the trial court be requisitioned. The registry to take steps for requisitioning the records list accordingly.
So there's an IA execution case is pending, your lordship. Title execution 1/24. We came to know about the decree only after filing of the execution case.
In title execution case, one issue notice. Next panel, hearts and so issue notice. Considering the fact that the connected regular second appeal number 72/2026 has already been admitted by formulating a substantial question of law. Hence, till next returnable date, the execution of the impugned decree is no execution till for next date. Further proceeding of title execution case number
1/2024.
1/2024 pending before the Court of
Civil Judge Junior Division.
Learned Civil Judge Junior Division Station
Not Salmana, Your Lordship, at
No.
Abhayapuri.
Not Salmana.
Abhayapuri.
Abhayapuri shall remain state.
Achha.
May it please your lordship. The appeal has been preferred by the plaintiff lordship. The suit was for specific performance of contract. Trial court decreed the suit and thereafter execution completed lordship. Then the defendant came. After receiving notice, defendant did not appear in the trial court. The suit proceeded ex parte lordship. Thereafter,
No. Again, repeat again.
lordship, plaintiff filed a suit for
You
specific
are plaintiff or defendant?
plaintiff lordship.
Okay.
Suit for specific performance of contract, and then notice was served. Notice, after receiving notice, defendant did not appear, so suit proceeded ex parte lordship.
Okay.
Then execution we have filed, sale deed was executed and plaintiff was also put into possession of the suit claimant lordship. Then defendant appeared, filed a title appeal along with a condonation application. Delay was condoned and appellate court reversed the judgment, saying that there was no prayer for recovery of possession. So the execution by misleading the court, the plaintiff has executed the decree. And the exhibit 1, this is not a deed of agreement for sale, lordship. On this, mainly on these two grounds, the appellate court reversed the judgment. So against this lordship, this regular second appeal, decree of reversal. And in the
In whose possession the land is? Land is in possession of?
in execution, we were put into possession and thereafter they have filed again execution petition. The first appellate court lordship not only reversed the judgment, the prayer of the appellant in the title appeal was to remand back the suit for de novo trial. But first appellate court lordship set aside the judgment and directed to set aside the execution of the sale deed, and the defendant was allowed to be put into possession. So that part also the first appellate court exceeded its jurisdiction. Page 87, your lordship will find appellate court judgment issue number 1, 2, 3, and 4.
Okay, what substantial? Mr. Mukherjee, you are appearing for the other side.
Caveat, lordship.
Okay.
Caveat is there.
What is the substantial question of?
Page 4, lordship. Whether the learned first appellate court was justified in dismissing the suit of the plaintiff in presence of exhibit 1, where it is clear.
What is exhibit 1?
Exhibit 1 is the agreement.
Sale deed.
They
No.
borrowed some money from plaintiff. The defendant borrowed 6 lakhs of rupees from plaintiff. And in that exhibit 1, it was written that if I fail to repay the money, then I will execute a sale deed in your favor. That is exhibit 1, where it is clearly mentioned that if she failed to repay the loan amount, the defendant will execute a sale deed. So as per first appellate court, this is not a deed of agreement for sale. This is an loan agreement, lordship. And it is already admitted by defendant that she borrowed money, that not 6 lakhs, but 3 lakhs, lordship. And one more is that whether the judgment of the learned appellate court was vitiated in view of the principle enshrined under Order 41, Rule 31. And whether the learned civil judge Chirang Kajalgaon committed perversity in not considering the pleadings and the evidences adduced by the parties in its proper perspective.
What is Order 41, Rule 31?
That is the appellate court has to decide all the issues or by formulating
Point determination.
lordship. And all the issues, there should be some reasoning, lordship. And in this first appellate court judgment, entire appeal memo was reflected in the judgment, lordship. And there was no reasoning given by the first appellate court. No specific reasoning. It is stated that the exhibit 1 is a borrowing agreement. This is not a deed of agreement for sale. Paragraph 61 is there, lordship.
Page number?
Page 106. But in the exhibit 1, there were 2 witnesses. I have adduced the evidence of 1 witness as PW2, Lordship. And she corroborated the statement of the PW1. It is held by the trial court. Paragraph 61 said, accordingly, the learned court below ought not to pass a decree for specific performance of contract on the basis of the money borrowing agreement, which is not at all an agreement for sale and is not a valid contract under the provisions of Indian Contract Act. From perusal of Exhibit 1, it is seen that Exhibit 1, it was written that the first party plaintiff respondent paid an amount of rupees 3 lakhs to the second party with a condition that balance amount of 3 lakhs to be paid in future, that is within 9-10th January 2018 for a period of 3 months only against payment of interest at the rate of 10% per month, which will be started from the date of borrowing, that is 29/12/2017, and the interest amount of the said principal amount will be payable to the first party respondent by the second party appellant monthly in time. Such an agreement cannot be considered as a valid contract because of the fact that respondent first party cannot charge such an abnormal rate of interest on the money lent. Further, the plaintiff respondent not being a money lender, having no license, registration certificate under the provisions of Assam Money Lenders Act, is not entitled to claim any interest on the money allegedly lent to appellant defendant. But the learned court below, without considering that aspect of law, has come to a positive conclusion on the alleged version of the plaintiff respondent, considering the same, and come to an erroneous decision. Then the discussion of valid contract and all this. The learned court below failed to appreciate the ingredients of a valid contract, and as a result passed the impugned judgment and decree ex parte without any legal basis, and as such deserves interference and
No, what was missing in valid contract?
Lordship.
How it is not a valid contract? What was held?
Agreement, Your Lordship, that is not annexed here. It was titled as money borrowing agreement, Your Lordship. There was no schedule of the land which was proposed to be sold. The only stipulation in the agreement was that the plaintiff has lent an amount of 3 lakhs, and 3 lakhs was supposed to be lent on a future date and at a rate of interest of 10% per month, Your Lordship. And if the defendant fails to repay the amount within a stipulated period, then she will sell her homestead land to the plaintiff. That was the content of the agreement, Your Lordship. There was no schedule appended as to what was the homestead land.
But Lordship, I am interfering in the submission of my learned friend, but there are so many citations which says even on the basis of oral agreement, specific performance of contract suit can be decided, Lordship, if plaintiff able to prove his case. In the trial court judgment, Your Lordship will find she 2-3 times notice was served, and thereafter defendant did not appear, Lordship. Thereafter the court proceeded ex parte, and plaintiff.
No. Why the first appellate court was wrong in holding the agreement to be a money lending agreement?
As because, Lordship, the defendant borrowed the money from plaintiff, and it is written that if I fail to repay the money, then I will sell the suit land. I will sell my plot of land to you. So that part is there. Though it is a statement that today I have taken 3 lakhs and in future I will take another 3 lakhs. But it is written in the Exhibit 1 that if I fail to repay, then I will execute a sale deed. And their prayer in the first appeal, Your Lordship will find the page 45. First appeal, their prayer is, it is therefore prayed that the Honorable Court may be pleased to admit the appeal, call for the record of so-and-so, connected title execution case number so-and-so from the court below, and after hearing the appeal parties, further be pleased to allow the appeal, setting aside the impugned judgment and decree appealed against, remanding the suit for de novo trial. But the first appellate court, without there being any prayer for restitution, 144 was not filed by the defendant, held in first appeal that Page 113, your lordship will find. Paragraph 77. Paragraph 77, considering the above, it is held that the learned civil judge junior division Chirang decreed the suit in favor of the plaintiff respondent in a hasty manner. The findings of the learned Munsif civil judge junior division Chirang are hereby set aside. In the result, the judgment and decree passed by the learned civil judge junior division Chirang is set aside and the appeal is allowed on contest with cost. All orders passed in title execution case number so and so are cancelled and set aside. The sale deed dated 31
Which page you are reading?
page 113. Paragraph 77, 78. 113, Lordship. Certified. This is citation.
Yes.
Paragraph 77, your lordship.
Yes, but the appellate court has power to do so. Power is there.
Lordship, there is a procedure of section 144 CPC, Lordship. After winning the case, the party has to file 144 petition for
Restitution
the
petition.
original decree, original court, Lordship, that is the learned trial court. First appellate court has no power to set aside the execution proceedings, Lordship. All orders passed in title execution case number 1/2022 and title execution case number 4/2023 by the learned Munsif civil judge Chirang are cancelled and set aside. This has to be done under section 144 by the winning party before the trial court, Lordship. The sale deed dated 31/12/2022 executed at the office of the sub-registrar, State of Maharashtra, Bijni in favor of the respondent and the mutation order dated. So, Lordship, after winning the case, the plaintiff executed the registered sale deed, he took possession and mutation records were also corrected. That mutation order was also, Lordship, directed to be cancelled. So passed by the circle officer Sidley, Revenue Circle, in mutation case number so and so in favor of the respondent is hereby cancelled. Let the possession of the appellant be restored and the name of the appellant is to be restored in the revenue record. And the khas possession of the landed property, land and houses is to be restored to the appellant. Prepare a decree accordingly within the prescribed time. So they have filed a title execution after filing of this lordship case.
You want to say something? We'll frame substantial question.
The ground situation is there was a decree, your lordship, ex parte decree, which was executed and my homestead, my house was put under lock and key. Though the agreement that they are showing as a agreement for sale, your lordship, is regarding a vacant land, but my land containing a house is under lock and key and under their possession in an execution, your lordship. After that, we filed the appeal. The appellate court has set aside the trial court judgment, your lordship. And at this stage, my petition under 144 is pending, your lordship, before the trial court. And since this appeal is pending, I think that is not proceeded further.
We'll decide it.
The first appellate court already performed the part of 144. The decision I have
But at
given,
present,
lordship, that
my
is
homestead land is under the possession of the plaintiff, your lordship, which was decided in ex parte decision.
as because after execution we have taken possession and the sale deed was executed, mutation was done, lordship. After that, the first appeal was filed with a long delay of 2 years, lordship. 2 years, then. Lordship will find this citation 1984 SCC 516, paragraph 19, 20, 21.
A substantial question of law as regards the appellate court, whether appellate court could pass order setting aside the orders in an execution case. I suppose that is the proposed question that is mentioned today. Your lordship, the appellate court has power. Once the appellate court has set aside a decree of the trial court, your lordship, the consequences of the decree that was passed by the trial court will automatically be set aside, your lordship. And the agreement, your lordship, in another aspect of the matter, the fact that it was a money borrowing agreement, whether there was any pleading or proof as to whether I have repaid the amount, or they are stating that I have taken a loan and I have given a stipulation that if I do not repay, I'll have to execute a registered sale deed of my land in their favor. Whether there was any stipulation, that is also a part of the appellate court's observation, that whether they could prove as a plaintiff that I did not repay the amount and thereafter I did not register my land to them. Because readiness and willingness in a specific performance case has to be proved by the plaintiff, and denial on my part.
Heard Miss R. Chaudhary, the learned senior counsel, assisted by Miss E. S.E. Murtaja, learned counsel for the appellant. Also heard Mr. B.J. Chaudhary, learned counsel for all sole respondent. Sole respondent. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant. Impugning the judgment and decree dated 19/2/2026 passed by the Court of Learned Civil Justice in a division Chirang, Kajalgaon in title appeal number 11/2024, whereby the said appeal was allowed and the judgment and decree dated 24/5/2022 passed by the trial court of Learned Munsif Chirang in title suit number 2/2020 was set aside and reversed. After considering the submissions made by learned counsel for both sides, following substantial questions of law are formulated in this appeal. Whether the trial court committed perversity in treating the exhibit 1 as only a loan agreement simpliciter, and not treating it to be an agreement to sell. Correct?
First appellate court, trial court.
No, by the Calica paper.
Whether the
No, instead of trial court, whether the first appellate court. Exhibit 1. Question mark. Whether, number 2, whether the judgment of the first appellate court not following Rule 31 of Order 41, can it be a substantial question?
exceeded its jurisdiction by
Okay, whether the appellate court, first appellate court, exceeded its jurisdiction in not complying with the provisions contained under Order 41, Rule 31 of CPC while passing the impugned judgment and decree. Number 3.
Section 144 is the procedure for restitution. That was, Lordship, the first appellate court
No, that is,
was the
these two will be suffice.
Lordship. 144, Lordship, for a moment, who is required? Application for restitution, where and in so far as a decree is varied or reversed in any appeal, revision or other proceeding, or is set aside or modified in any suit instituted for the purpose, the court which passed the decree or order shall, on the application of any party entitled in any benefit by way of restitution or otherwise, cause such restitution to be made as will, so far as may be place the parties in the position which they would have occupied but for such decree or part thereof has been varied, reversed, set aside and modified. So as per this 144 CPC, Lordship, if any party is entitled for any reversal or modification of the decree and thereafter they are entitled for any relief, Lordship, for that they have to file a 144 petition.
Yes, but what appellate court did?
Appellate court, without there being any application, set aside the decree of the trial court and granted every relief which is entitled for a winning party under section 144.
Whether the first appellate court exceeded its jurisdiction in directing the possession of the suit land to be restored in favor of the
Defendant.
Ignoring the provisions contained in section 144 of the Code of Civil Procedure. Stop. Let the records of, since Mr. B.J. Mukherjee has already appeared for the sole respondent, no necessity of issuing any formal notice is there. The appellant shall, however, furnish a copy of memo of appeal along with the annexures to the learned counsel for the respondent within 2 days from the date of this order. Let the records of the trial court as well as first appellate court be requisitioned from the respective courts, registry to take steps. Stop. Let this matter be listed again on 29
Lordship,
July
there is an IA for 1175 for stay, Lordship.
after receipt of the records. Stay.
Stay, Lordship, after filing of this case, we have received the notice from
We have
title
filed
execution.
144 proceeding, Your Lordship, because the decree was set aside, Your Lordship. Because my homestead land is under their possession as of now, Your Lordship.
No, but now that question has been raised,
That question.
unless it is decided.
Lordship,
In
may I
that event,
submit
it will
the
stay.
notice?
And I may be permitted to urge a prayer for early hearing of this matter because there is a scope of remand by this court as well, Your Lordship.
We are fixing date.
Lord.
We are fixing a specific. We have fixed a specific date.
Ready to argue the case after receipt of the LCR, Lordship. This is a notice, Lordship, we have received after filing of the appeal.
In the stay, Lordship, it may be stayed till the next returnable date with an endeavor that it may be, the appeal may be
Yes,
heard or
Lordship,
rejected.
I have no objection. title execution case number 04/2026. That was not mentioned in my IA, Lordship.
Lord Miss R. Chaudhary, learned counsel for the applicant slash appellant. Also heard Mr. B.J. Mukherjee, learned counsel for the opposite party slash respondent. This interlocutory application has been preferred by the applicant in connection with regular second appeal number 38/2026, praying for stay of the execution of the impugned judgment and decree dated 19/2/2026 passed by the Court of Learned Civil Senior Division, Chirang, Kajalgaon in Title Appeal 11/2024. Stop. It appears that in the connected regular second appeal, the substantial questions of law have already been formulated and said appeal has been admitted, and the records of the trial court and first appellate court have been called for. Hence, considering the fact that the second appeal, connected second appeal has already been admitted, the impugned judgment and on decree the execution of impugned judgment and decree in the execution case number 4/2026 dated in 2026 pending before the Court of Learned Civil Judge Junior Division Sirang shall remain stayed during the pendency of the connected regular second appeal. Stop. The parties are agreeable to
Lordship, that may not be recorded after receipt of LCR. My learned friend can file an early hearing petition. Otherwise, this will be a precedent for all the second.
This is not a bad precedent.
Lordship, we will be happy, but Lordship,
Will be
maybe for registry, it may not be possible to list all the regular second appeals, Lordship. Still,
yes.
2010 RSA are pending, Lordship.
क्या लिखा?
তুমি একটা ফাইল করে দিও, আমার objection নেই।
नहीं, वो काट दीजिए. Stop. This interlocutory application is accordingly disposed of.
Lordship may kept it as a part of record, as marked it as X,
Yes.
as because we have received after filing of this.
The notice received by the applicant in execution case number 4/2026, which has been produced by learned senior counsel today before the court, is marked as X and kept as a part of the records of this interlocutory application. This interlocutory application is accordingly disposed of.
I'm deeply obliged.
Item 46.
Lordships, in this case, on the earlier occasion, we sought time for the honorable court on the ground of losing of the case record, your lordship. So I have managed to get some of the record, and the evidence and the exhibited documents are yet to be received from the certified copy section, your lordship. So I need some time for reconstructing the entire, your lordship. And as agreed in between my concerned learned senior advocate and my senior, your lordship, that there further date may be fixed for hearing in this case, your lordship, because my senior will come and argue in this matter, your lordship.
This item number? Heard Mrs. Das Gupta, learned counsel for the appellant. Also heard Mr. G. Bhardwaj, learned counsel for respondent number
1, 2, and 3.
1, 2, and 3. Learned counsel for the appellant has submitted that on an earlier occasion, the appellant sought adjournment on the ground that the records, the brief of the case has been misplaced and some time is required for reconstruction of this claim. As such, the appellant has applied for certified copies of relevant documents, and some of the certified copies are yet to be received. And as such, she prays for some more time for arguing this case after reconstruction of the after receipt of the aforementioned certified copies. The prayer is allowed. Let this matter be listed.
Subject to your lordship convenience, can it be on 13th of August?
Yes, as we have noticed, my senior will come
13th.
of August.
13th. 25th August.
If it is hearing date, then I will inform my senior.
25th August. Hearing day hoy ne? Let it be listed on 25th.
Highly August.
Nish.